I'm just that item number 17. If the business of the court goes in this manner, then I'll wait for my schedule. Otherwise, may kindly be upgraded. I'll make it. Oblige,
We'll see what we can do.
my lord.
May I please, your lordship?
Yes.
Lordship, I beg to mention item number 21.
21.
The other side has a concern and they also have certain difficulties, lordship.
At 2015, what are we
Yes,
waiting for?
There are certain, at this point of time, CU is only praying for the benefits of stagnation and service. So which is also been under consideration right now once again.
Hmm.
That also maybe I'll have on the next date to place before your lordships.
Give us a date which we can-
11th of March that we have agreed for that.
Huh?
11th of March. When the other side has, they also have some difficulties. So we concentrate.
2015,
Yes.
you have difficulty, other side has difficulty, petitioner is facing difficulties. We are in difficulty, huh?
The Lordship, the arguing counsel is unwell, therefore I pray for an adjournment.
Who is unwell?
Askadi of court.
He's also not keeping well. So that's why we have
Okay.
agreed for a date, Mitchell did.
We are not happy. On a joint request made by the learned counsels appearing for the parties, list this matter again on the 11th of March 2026 full stop. The court notices that the matter is of 2015. And earlier orders of the court has also reflected the said position. Full stop. It is made clear that on the next date of listing, the matter would be taken up for disposal.
Sure.
Counsels are requested to be prepared accordingly.
Yes, Lord. Obliged.
I would may not like to take up item number 30.
13,
30, 30, my lord.
30.
Requested from Mr. D. Gogoi, my lord. I'm not in the brief, my lord. My friend Mr. D. Gogoi had requested me to make a mention.
List this matter before a bench without me.
But there's an interim protection, my lord.
Can I?
Since your lordship is not taking up the matter and interim also, my lord.
I cannot take up the matter.
She will not touch the matter, so the interim stays. Is my submission.
Make a mention tomorrow, get it listed.
I'm grateful, my lord.
It will be proper. Okay.
Hello.
Interim order passed earlier continues.
Grateful, my lord.
Yes.
Please, your lordship, I beg to mention supply item 29, lordship. Kindly pass over the matter for the day, lordship, and kindly fix it on tomorrow, lordship.
The request of the learned counsel appeals to the petitioner, list this matter again tomorrow.
Yes, Lord.
Validate it.
Much obliged.
Yes. Item 23. No, no. In item 23, take down. An adjournment slip had been circulated.
53.
In this matter, praying for listing of the for an accommodation for the day. List the matter again on. Can we have a date?
Well, give me the first week of March.
First March, or did you? Agreeable for mediation.
So here in this case, a miscase was filed by the respondent, your lordship. That is 3760/2025 and it was actually disposed. 1911/2025, whereby as part of accommodation of the budget, they will provide us a rupees 5,000 per month, and after getting the budget fully, then they can complete the whatever the amount. Now, issue remains is that we have not received a single penny after passing of the judgment.
So today the matter has come up for whether you'd like to have it referred to mediation. If you want to have it referred to mediation, we'll send it for mediation. If you want it to be adjudicated on the next date, we'll fix a date for adjudication.
Mediation is nothing that they have to give a report that where if they have sent reply on the amount, there's nothing. So I may be allowed to go for the education otherwise.
Adjudication.
Yes, yes, nothing is.
although this matter has been listed in the column for referral to the special mediation drive, comma, the learned counsel for the petitioner submits that mediation would perhaps not bring a solution to the issue and it will require adjudication, full stop. Accordingly, list this matter again on March, or did you? Sometime, no? 10th of March,
Lots.
2026, in the, it was in admission,
Yes.
for admission.
Lots. Maybe the last. Let us try, my lord.
You are asking for regularization.
He's saying
Can it
that
be done on
nothing will
mediation?
happen. My lord,
Can it be done on mediation, some
let us
regularization?
try, my lord.
Huh?
Let us try, my lord.
It's regarding entitlement, my lord. How the mediators would solve the problem, I don't understand. Because
He cannot adjudicate on the dispute,
A dispute is that, my lord, they have.
whether you are required to be regularized or not.
The petitioner was sent to on lien on a foreign assignment. So now he retired there, my lord.
Hmm.
And now he's claiming his retirement benefits, my lord. And yeah, the health department has filed their affidavit. In that affidavit, it says that, my lord, that we have to apply for the pension, my lord.
Why did you not apply? Why don't you apply?
the moment
If it is apply, no reply, then we will see. But if you don't apply, what can we do?
But the thing is that, my lord, he stays outside, my lord. That's my lord. The fact, my lord. He's outside, my lord. And where to apply, how to apply, my lord, he do not know, my lord. They have to help us, my lord.
Huh?
My lord. Yes, they will help us, my lord. That is the thing. my
Which
lord.
department? Railways?
Health,
department.
health.
Health.
Yes.
Why does the health department not help?
He'll have to approach the department, my lord. Then
No,
they will
no,
give
no,
the
no, no,
papers
no.
and you'll sign it.
And my lord, this is the second round of litigation. Lordship will find the.
You want an adjudication, sir, or you want a mediation is what we are asking.
They
today.
have to help us, my lord.
Okay. So, sir, वो ऊपर वाला तो रहेगा ना वही वाला? Parties have agreed that the matter can be, then an attempt can be made to sort out the matter on mediation accordingly.
My lord, Lordship appointed, my lord, this point, my lord. Since they have filed the affidavit.
For
They
mediation,
have
we
to
are
help us,
not.
my lord. In applying the pension papers, my lord. We
Mr.
don't know,
Das,
my lord.
kindly understand. If this court is to pass an order, we'll pass an order while we are trying to adjudicate it. If it is to go for mediation, any observation from us either is a burden on them or will be a burden on you.
I agree.
Is it not? Mediation, we keep everything open. Do what you want.
My lord.
Come to any agreement which is lawful, if not legal. Any lawful thing we can agree to. Do you want a mediation or do you want some orders passed
Yes,
by
my
this
lord.
court? Mediation. Mediation. Parties to appear before the mediation center on, is a, mediation center. 24th of February. Huh?
Bless you.
Yes,
Again,
Well,
mediation.
Lordship, we were agreeable, Lordship, but the
agreeable to
respondent
mediation.
is the
Well, this is regarding pension, regular pension and retirement benefit.
Ah.
Unlikely to depend on someone will come and say, yes, he is entitled to. The criminal cases are going on. Provisional pension, he's getting it. Unlikely.
we were agreeable, Lordship. They have some difficulty, Lordship, and take up the matter of 2 weeks.
Otherwise, we take it up for adjudication.
Not
whether you
particular,
get it or
should
you
take up
don't
for
get it.
education.
After 2 weeks, Lordship.
Huh?
After 2 weeks, Lordship.
After 2 weeks, parties submit that mediation would not bring about a solution to the issues raised. Is this matter again on? We'll have it on March 11th.
What's
11th
11 months.
what?
in the admission column.
Problem.
You have filed your affidavit?
Yes,
sir?
sir.
Okay.
Lordship, I am
Yes.
appearing on behalf of the Ace Salukdar, my lord. So this matter referred to the mediation, my lord.
It can be referred.
Yes, my lord.
Let it go, let them try once, my lord. If things work out.
Parties are agreeable to attempt a conciliation during the mediation process. Is before the mediation center on parties to appear before the mediation center on 24th of February. Appear before 24th. List thereafter along with mediation report. Huh? 5. It has immediate.
Matter referred to the mediation center, Lordship.
Lordship, here I am appearing on behalf of ONGC. Other respondents are also there. We do not have any objection for referring the matter to mediation, Lordship.
Agreeable for mediation? Is before parties to appear before the mediation center on same date 24th of February 2026.
Lordship, any date 25, I have a family that is
When do you want it? 27th?
28, Lordship.
28?
8, Lordship.
Sir, you'll have to sit alone.
As a family marriage
You have
ceremony.
to sit alone.
The March first week, Lordship.
There is a calendar. Kindly see 20th
Oh.
of February. Can we grant? Okay. 5th of March.
Yes, Lordship.
5th of March?
Yes. Obliged.
Obliged.
नहीं रहने से ज्यादा ठीक है।
On the last day, Lordship had asked for a type copy of page number 106, your Lordship.
Huh?
Lordship had asked for a type copy of page 106, your Lordship. What does it?
क्या चीज है?
Page 10. So I want a type copy of this.
Uttered by me.
Lordship.
Do I forget everything? Some persons who did not have the field experience, they were supposed to be given it immediately on their promotion. Is it that matter?
Lordship, we had.
That was part of that
Lordship,
matter, no?
We had
Those
completed
who have been promoted, they were required to be posted to the
the
field.
field posting, Lordship,
to
plus
get
certain
their
violations of
experience.
the.
That was one part of it. What was the other part of it?
Other part was Lordship violation of the transfer, the promotion policy, your Lordship. By NHPC, not signed by the executive director, not signed by the executive, order not passed by the executive director, your Lordship, for
Hmm.
promotion. And third part was, Lordship, that the entire selection process, the promotion process has some anomalies, Lordship. We are not granted 1 mark for our paper, your Lordship, extra paper obligation. That matter, your Lordship.
Just quoted down what we have heard. A little forgetfulness on my part.
Lord, it happens
So
because.
questions may come up when you are making your submission.
Yes. In fact, I reached here on the last occasion at the right moment when the final summation was being done. So I could jot down all the points. In any case, my lord, it is a reiteration of what was argued earlier. Because this matter was heard at length. It was CAV. Written arguments were given from both the sides. Judgment not delivered. Learned judge got transferred. And again, matter came up for hearing.
Yes.
So each of us know about the other
Lordship.
as to what points are to be argued.
Lord.
So I'll highlight all those parts.
Yes.
And we'll give the answer. Now, my lord, I understand. I have been given to understand because I myself have not checked. I have been given to understand that the written argument and the relevant records of the case, which were handed over, they were not found. This is what I was told. Because
one bundle is available here.
May I have a look, my lord, in that case?
Submissions.
Because it may turn out to be precisely what was given by us on the last occasion. I'll have a look. It is theirs. Yes, this is ours.
who had to frame the committee and
Correct.
whether the approving authority had, whether the DGM or someone was the approving authority or he had to frame the committee that.
No, my lord,
was
yes.
perhaps-
Everything is here. The only thing is, yes, correct. Even the records are also here. Records are here. Promotion policy, followed by DPC proceedings. This is the marks, DPC proceedings. Yes. There was another constitution of yes, look, no, this is there. I have seen it. DPC proceedings, division of marks, motion policy. There is another regarding the constitution. Constitution I will hand over.
Lordship,
I
even I
think-
bought my written submissions, Lordship.
Yes.
Lordship.
My lord, it is
Is it the
precisely
same which is
this.
on record?
Yes, everything is here.
Yes, it's there on record. Lord.
It is
the
there on
same-
record.
We don't need another.
His written argument, my written argument,
Everything
everything
is
is
there.
there on record. Now that my lord, there is only one thing.
Hmm.
Since certain corrections, only typographical errors and few sentences here and there, certain corrections were made in the final write-up. When I read all this, I found certain corrections were required to be done. So may
Can
I
we achieve
replace,
that? Can
may
we
I
achieve-
replace my written argument with the corrected written argument?
Replace
No
it.
substantial change, only
If you
English.
also want to replace it, you can replace it. No.
Because I don't know again, maybe something is one or line here or
Ah.
line there. So better I. Even if you want to have, I can give you another.
Can you use it now, can-
Sure, very well, very well, very well, very well, very well. There's no change. Everything
I'll-
remaining the same.
The copy from you. The matter is done. Matter-
He will give you. Huh? Now, all other things remaining the same. So, my lord, now, my lord, so far as the respondents are concerned, I'll present their case.
Hmm.
My lord, what exactly is the issue?
I mean, permitted to take down his note submissions alone.
Yes.
Permitted to take down his submission alone.
Even without the permission of my lord, you are always at liberty. That is their right. The issue, my lord, is the promotion of the petitioner from E5 to E6. E5 he was working, he was, the E5 position is manager civil. The issue was his promotion from manager civil to senior manager civil. Senior manager civil is E6 grade. So the whole case is, since he was denied the promotion, he came before the honorable court, assailing the recommendation of the DPC because it was the interview, my lord. The reason for which he was denied the promotion was his not getting the qualifying marks in the interview. Now, getting qualifying marks in the interview was an essential requirement for attaining the suitability for promotion. The two expressions were used, eligibility for promotion and suitability for promotion. So far as eligibility is concerned, he was indeed eligible. But so far as suitability is concerned, he could not score qualifying marks in the interview, as a result of which he was declared not suitable and he was denied the promotion. It is a different matter though, that the next year again when the DPC set, he was promoted. And presently he is E6.
Where do we find the
I will
interview-
place
The
everything.
interview that he has.
My
to
lord,
face the
I
interview?
will place it.
Ah.
I will show the proceedings of the thing, of the interview to your lordship. I will place everything. And I will answer each of the questions, my lord, which they have raised.
Kindly continue.
Now, my lord, to begin with,
Mm.
since one of the important facet that was argued was the institutional bias.
Mm.
One of the argument was the institutional bias. So the institutional bias, as we all understand, as if it is the organization as a whole, the people who are at the helm of the affairs in the organization, they have some kind of a prejudice towards the person. Since they have the prejudice, they do not want the person concerned to get a certain position. This is what we understand by the institutional bias. In the institutional bias, no bias specifically is attributed against a particular individual, but it is the organization as a whole. Now, my lord, so far as this aspect is concerned, let us appreciate that the petitioner joined NHPC as junior civil grade 2 on 19th of January 2004. The details I have given, I am just giving the summary of it. He joined NHPC as junior engineer civil grade 2 on 19th of January 2004. He became trainee engineer civil on 1st of July 2008 after 4 years. Thereafter, he was promoted to engineer civil on 1st July 2009. Another promotion to assistant engineer civil on 1st of April 2014, followed by deputy manager civil on January 2017, and then manager civil, which is the E5 grade, on 1st of April 2018. So, my lord, from the period January 2004 to April 2018, that is 14 years, he was promoted 5 times. He was entitled to all these promotions, and on each of the occasion at the right time, he was promoted. Total, he got the 5 promotion. Now, my lord, after he was promoted to the position of manager civil in E5 grade on 1st of April 2018, as per the promotion policy, the next higher post for promotion was senior manager civil, which is E6 grade, senior manager civil. Now, I will take your lordship to the clause 8 of the promotion policy. My lord may have a look at the clause 8 of the promotion policy. Promotion policy is with the record. My lord will find it there. The bundle which my lord had given me, there the promotion policies there. We had given a copy.
They're also in the writ petition, sir.
My lord, but writ petition, there may be difficulties because pagination, legibility, etc. And there were certain changes. So we give the better copy. My lord will find there.
Executive establishment 2022.
My lord, promotion
Is there
policy,
one?
my lord would find like this. Yes, that is DPC proceedings.
One, two, 2.2. This one?
Yes, yes. This is promotion policy.
Okay.
All the relevant things are there, my lord. So, lordship will turn to the clause 8 of the promotion policy.
8.
Yes. Clause 8 gives a chart which shows qualifying period for promotion. Now, here my lord will find E5, salary grade E5 to E6. Now, lordship will see the qualifying period for promotion, 4 years. So, the qualifying period for promotion is 4 years under clause 8. Since, my lord, he was promoted as manager civil on 1st of April 2018, he was naturally eligible for promotion. He completed the qualifying years of 4 years on 1st of April 2022. That is the eligibility. Once you complete the qualifying years of service, you are eligible for promotion. So he became eligible for promotion on 1st of April 2022. Now, because 1st of April 22 would be significant primarily for another reason. One of the argument is, look here, the DPC ought to have been constituted effectively for 1st of April 2022. It was constituted earlier. Now, my lord, had it been constituted earlier and had the promotion been considered earlier,
He would not be there.
yes, it was for his interest. I will deal with that part, of course. So now, my lord, after the qualifying years of promotion, clause 8, I will come to the basis of promotion. What is the basis of promotion? The basis of promotion, my lord, will find clause 4.7. I'm dealing with the relevant clauses.
Eligibility and merit
Basis of promotion.
subject to suitability.
Yes. Promotions up to E6 grade shall be based on eligibility and merit, subject to suitability. The last part, my lord, that is directly connected with the interview, I will show that. Merit inter se, among all those who qualify, the merits and the suitability. So far as the merit is concerned, my lord, in the very beginning, I am making it very clear. So far as the total marks are concerned, he made it. Total marks, he made it. But because of not getting qualifying marks in the interview, he was denied the promotion. It was primarily on the count of suitability. Merit was not the issue. Eligibility was not the issue. It is the suitability. So the merit got affected or merit got eclipsed because of suitability on that very year. So thereafter, my lord, clause 4.9 is equally relevant after 4.7. 4.9.
4.9, yes.
It reads, qualifying period as fixed shall be to determine the eligibility of executives for consideration for promotion to the next higher grade post, and hence mere fulfillment of eligibility criteria will not confer any right on promotion to the executive or even right for consideration for promotion. That is the settled principle of service law. Had it not been there, then also possibly my lord would have taken this line. But anyway, it has been made very clear in clause 4.9 that qualifying period is only for the purpose of eligibility. And it doesn't confer any right per se. Now, my lord, I will come to constitution of DPC, the point I made earlier. The constitution of DPC, my lord will find the relevant clause is clause 10.1. 10.1. reads, the departmental promotion committee shall be constituted only once in a year, effective from 1st April. Now the language is, the word used is effective from 1st April. One may constitute DPC in the month of March or month of February or month of January. The point to be noted is on which date it will be effective. Because these are the official formalities. We will pass an order, we will get the people. So we may constitute DPC, but when the DPC will be effective? Effective from 1st April. So it is not the date of the constitution, it is the date of effectivity of the DPC, which is relevant.
Could the petitioner have been considered for promotion for vacancies arising for a period when he was not eligible to be considered?
It cannot be these are settled principles.
So the vacancies should have been on 31st March. Vacancies which existed on 31st of March 2022 were required to be considered by the DPC.
Yes, and in any case, that is
Petitioner
the issue. Nobody is raising these
on-
questions.
Petitioner becomes eligible on 1st of April.
Yes. But my lord, since the constitution has its own requirements, we have to get the right kind of people for the purpose. So the order of the constitution can also be passed earlier. The question is when it will be effective. Because we know DPC has to be there. We know very well DPC has to take into consideration the vacancies.
We are on a different pedestal. We are not exactly on the line you are arguing. I was asking another question. The vacancy arose prior to 31st of March.
Yes.
Petitioner became eligible after the 1st of April.
My lord,
Could he have been considered?
my lord, we have since my lord,
Since you have considered.
NHPC has not disputed this aspect. It is 1st April, and we know 1st April he attained the eligibility. Since he attained the eligibility effectively from 1st April, we take him to be eligible. My lord, there is no exception. We don't make any exception. We have treated him eligible. Likewise, we have treated many others eligible. So fair enough, my lord, that is not an issue.
You will find the answer on page 77, your lord.
But in any case, nobody is disputing this.
Keep a note of it. We'll come to that.
We are not disputing this aspect. His eligibility is not in question.
Hmm.
We take him to be eligible. We take him to be eligible, please. Please, we take him to be eligible. That is nobody's case. Now, my lord, 10.2. 10.2, Constitution of the DPC. But anyway, let me read 10.1. The Departmental Promotion Committee shall be constituted only once in a year, effective from 1st April. The vacancy will be calculated after considering the following for determining the number of vacancies as on 1st April. I am not reading that, my lord, because as to how many vacancies, whether vacancies were falling short, vacancy is not an issue at all in the present case. Nobody has argued it, and I'm sure my learned friend also have not argued it. This issue is not in question. We accepted petitioner as eligible and we considered his case. Now 10.2. The constitution of the DPC for the consideration of promotion for the grade of E8 to E9 shall be approved by the CMD, and for the consideration of promotion for the grade up to E7. Now we are dealing with this aspect. I repeat, for the consideration of promotion for the grade up to E7 shall be approved by the director personnel. The DPC shall have one external independent expert. The composition of DPC shall be as per Annexure 4. So, my lord, so far as the DPC in the present case is concerned, the requirement of the law is, as per clause 10.2, the up to grade 7, the DPC has to be approved by the director personnel. The DPC shall have one external independent expert, and composition of DPC shall be as per Annexure 4. Let us turn to Annexure 4, my lord, which is tagged with the promotion policy itself. Annexure 4. Just I am showing the relevant provisions. Annexure 4, my lord, column 4, para 4. The last but one page. The DPC consisting of following members shall be constituted by the director personnel. Para 4, my lord, have got it? Yes. The DPC consisting of following members shall be constituted as per the director personnel. Now, my lord, I recall when my lord gave me that very bundle, I did not see the relevant papers concerning the constitution of DPC. So therefore, my lord, I think I should give this. Possibly this is not there. Proposal for constitution of DPC. I will point out the relevant portions, my lord, of this. Now, my lord, in the present case, I will demonstrate, my lord, with the help of the constitution part, the relevant papers that I have given to your lordship. I'm just showing the provision right now. Who were the people? I will show that first GGMHR or stroke GMHR. In the present case, it was GMHR, one of the member. GGMHR was not, it was GMHR. The GMHR happened to be RT Nathan, SC. He was SC. Then second, it was GM of technical discipline. The GM of technical discipline in the present case was Anand Kumar, electrical. He was from electrical branch, technical. Then the GM of non-technical discipline. In this very DPC, the person concerned, the member concerned was Kopili Lakshman Acharyelu. All these names, my lord, will get in those papers. And then external independent expert was Mr. N.V. Kumar. He is from, my lord, National Power Technical Institute. It's a different organization. So from there, my lord, he was brought as external independent expert, Mr. N.V. Kumar. My lord will get his name. Now, lordship will just see the important aspects regarding the constitution. In case there is no SC, ST, OBC, minority women member in the DPC, additional members belonging to these categories shall be co-opted not lower than E7 label. So,
Manager law comes in there.
yes,
And
my
that
lord.
is the woman.
Yes, yes.
Minority is already there.
Minority, my lord,
Come
in
on.
this case, my lord, so far as minority is concerned, the minority member was the chairman of the DPC.
A.K. Jain.
Yes, he's Jain, my lord. He's from a Jain community, and my lord knows very well the Jain community has been declared to be a minority. I have, my lord, I have shown that. Notification was issued by the government of India, declaring Jain community as a minority community. So this chairman happens to be from minority community, Mr. Jain, A.K. Jain. Then, my lord, SC, ST, OBC, minority women. Now, in the other case, my lord, Madhusmita, General Manager Law, the then General Manager Law. Now the lady is Executive Director Law. At the relevant point of time, she was General Manager Law. So she represented women. She also happens to be OBC. So women plus OBC combined. So this is what the constitution of DPC was. I repeat, GMHR was Mr. R.T. Nathan.
ST was
SC?
not represented.
My lord, because now that Madhusmita, the then GM law, happened to be women as well as OBC, the requirement of ST was not there. Because Lordship will see the column immediately after the constitution. In case there is no SC, ST, OBC, minority women member in the DPC, additional member belonging to this category shall be co-opted. Because total numbers, my lord, the DPC consisting of following members shall be constituted. 4, 1 minority, and 1 has to be from the reserve categories. The requirement is complete. From SC, ST, OBC, minority, women, there has to be 1 representative. So here, my lord, minority and women and OBC.
But ST was not there. It's a fact.
SC not there, ST is not there, but women as well as OBC and the minority.
SC and ST are not there.
SC and ST are not there, but women, OBC.
minority and women.
No, my lord, SC is also there.
That is what.
Sorry, SC is also there.
You said SC.
The General Manager HR,
It's
Mr.
a-
R.T. Nathan happens to be SC.
Only ST is missing.
Only ST is missing, all others are complete. So, my lord, there is no defect as such with the constitution. It is not sine qua non that ST has to be there. SC is there, OBC is there, women is there, minority is there. And all other members are complete, having the relevant designation. But in any case, otherwise also, the issue would be how petitioner is prejudiced. Had the petitioner being ST, had it been his case, there was a bias against the ST representative was not there, I would have understood.
Yes.
Now, my lord, I'm just giving the entire, my lord, summary, the whole prospectus of the case. After the constitution of DPC comes the issue of assessment of merit and the division of marks. Lordship may turn to Annexure 3 of the policy.
To the policy.
Yes.
Yes.
Because Lordship will find the Lordship question why ST, SC dash ST, the way it is put, SC here in the call in the para 4, SC dash ST. Lordship will just see para 4. Regarding the constitution, my lord, question only ST is missing. I'm just clearing it.
Where?
SC dash ST.
Where?
My lord, the para 4 of the promotion, para 4 of the constitution of the, para 4 of the promotion policy.
Promotion policy.
Yes. Para 4. Immediately after the composition,
Promotion rules. No.
the promotion policy, this one.
No, this one.
Yes.
Where do I find the
Last but 1 page, para 4,
Last but 1 page.
last but 1. I'm clearing that doubt in my lord's mind that only ST was not there.
What has not been argued? We are not.
Even then, I'm just clearing. Since my lord, the doubt came to your lordship's mind, I'm clearing the doubt.
According to you, SC dash ST would mean that it can be either an ST or an ST.
SC dash ST, then stroke. So if, my lord, if we really go into the hair splitting exercise, nitty-gritty interpretation of statute, what is the meaning of dash, what is the meaning of oblique? So
Without commenting on what we are thinking right now, we do not agree to your that proposal because care was taken to have a woman, care was taken to have a minority, care was taken to have an OBC. We say woman because woman was given an emphasis. OBC could have been left out, but no, an OBC member has been identified.
SC was also there.
SC was also there.
Minority is also there.
Why the ST was?
The reason is SC
We don't
dash
want to
ST.
know. They have not raised it. We don't want to know. We
It's
just-
nobody's case.
we noticed, we expressed.
SC dash ST. So either or.
We noticed, we expressed.
Yes. And dash may not, if we go into the interpretation
Yeah,
of
not good.
statutes,
Yeah, not
very well. Now comes the assessment of merit, Annexure 3. Annexure 3. In annexure 3, the first column, the grade. My lord will see E5 to E6. First column E5 to E6. Now, Lordship will just go to the extreme right. The last column, E5 to E6. First of all, the breakup of the marks are given. Par marks, total 60. Performance appraisal report. Performance appraisal report carries 60 marks. Seniority, the third column, 10 marks. That is 70. DPC marks interview, 15, makes it 85. Field exposure, 10, comes to 95. Qualification marks, extra qualification, additional qualification. They have argued this point and I will concede their argument. 5 marks, total makes it 100. Total marks 100. Now for general, the qualifying marks in the interview minimum is 8. That is out of 15, the minimum qualifying marks. Lordship will find at the very top, minimum qualifying marks. For general, it is 8. For par, it is 44. In par, out of 60, general must get 44. In his case, the petitioner got more than 44. In par, his marks are good. Interview, qualifying marks are 8 out of 15. In his case, he got 6, not 8. Likewise, for SC, ST, in par, it is 40, interview 7, minimum qualifying marks. So this is the breakup, the total breakup, as per the policy. Now, my lord, suitability, eligibility I have shown, the merit I have shown, the breakup. Now I turn to assessment of suitability. For assessment of suitability, the relevant clause is 10.5 of the promotion policy. The DPC shall interview executives in the grade of E1 and above and up to E5 with a view to ascertain their suitability for the next higher position. Marks for interview shall be awarded by the DPC taking into consideration factors like. Now, my lord, I give emphasis to the expression the DPC shall interview executives with a view to ascertain their suitability. So, my lord, it is by way of interview suitability is ascertained. Interview is the only basis that also would answer one of the fundamental questions they raised, that the marks in interview should be given on the basis of performance appraisal report. I will deal with that. This was argued, I believe, that performance appraisal report, all the parameters are there. Why should that not be taken into consideration for ascertaining suitability? Why interview? Now, here interview is for suitability as per the policy itself. Suitability has to be adjusted by virtue of interview. Now, my lord, what factors will be considered by DPC while carrying out the interview? The factors are total 12. Now, out of these 12 factors, at least, my lord, 8 factors I will point out, or 8 parameters I will point out, where element of subjectivity is involved, purely subjective. Because once members of DPC are sitting over there, they can ascertain those qualities only by interviewing a person. It can't be, my lord, ascertained by looking into the papers. You have to talk to a person and get those necessary feedback from the person as to whether he is fulfilling those parameters. What are these parameters? Professional knowledge. Of course, one may argue that professional knowledge, even you look into his qualification, you look into his performance appraisal report, but my lord, interview is also one of the very important aspects of judging the professional knowledge. My lord, while interviewing the judicial magistrates or even for district judges, would be asking legal questions. The professional knowledge, the working knowledge. What kind of knowledge do you have? How do you how do you understand and appreciate the problem and analyze it? Professional knowledge. Ability to reason out logically. Ability to reason out logically. 3, presentation of ideas coherently. That is number 5. Presentation of ideas coherently. Ideas coherently, my lord, only by talking one would ascertain. Environmental awareness, only by talking one would ascertain. Leadership, potential for decision making. 8, communication skills. 9, sense of involvement. 10, commitment to the organization. So far as educational qualification at the very top is concerned, yes, looking at the paper. Consistency in performance, PAR may become the basis. Then 11, recognition, appreciation letter of director, CMD, etc. Yes, paper. 12, warning, caution letter issued by disciplinary authority. Yes, maybe document and paper. But on 8 counts, only the DPC can ascertain the suitability and award marks. So 10.5 is gone. Now I come to the interview. Interview, my lord, I have already shown. Total marks 15. Of course, the relevant clause is 11.5. 11.5. The marks in interview, though it is shown in the annexure, but clause 11.5 specifically deals with it. 11.5, lordship may have a look. The DPC will award up to a maximum of 15 marks to each eligible executive for interview in terms of subpara 10.5 above. 10.5 I have already shown to your lordship. So 10.5 will be the basis for awarding of marks. Total marks 15. One can maximum get 15 out of 50. Qualifying marks for general being 8 and for reserve category being 7. Now, my lord, I turn to the arguments. Now, my lord, I'll take your lordship to my written argument itself. I'll point out the relevant portions. Because instead of, my lord, since everything is here in black and white, it will be easy.
Yes.
Paragraph 3, my lord, onwards, my written arguments. Para 3 first. Lordship has got it? Para 3. In February 2022, the DPC was constituted to be effective from 1st April 22 for recommending promotions of manager civil E5 grade to senior manager civil E6 grade. However, with necessary changes in its composition, it was finally reconstituted with approval of director personnel only on 9th of March 2022. My lord will find that in constitution of DPC, those papers which I have given to your lordship. The approval of director personnel. This was in terms of clause 10.1. This was in terms of clause 10.1 of the promotion policy, which mandates that DPC shall be constituted once in a year effective from 1st April. Since DPC was to be effective from 1st of April 22, and the petitioner was also completing the 4 years of qualifying service as manager civil E5 on the very date, he also became eligible for promotion to senior manager civil E6. My lord, pausing here, I clarify, had it been a case that the petitioner was not even considered for promotion, and had there been a litigation, I certainly would have taken the ground which fell from your lordship. That when did the vacancy arose?
No, that is clarified in an example.
That is why. But hypothetically, my lord, such an argument could have been advanced. Para 4. On 4/3/22, Para 4. On 4/3/22, circular was issued by the NHPC calling eligible candidates for interview. Total 24 candidates from the cadre of manager civil E5, including the petitioner, were called for interview, as they all had completed the qualifying 4 years of service in the cadre of manager civil as on 1/4/22. So total 24 were called because all of them had completed 4 years of qualifying service as on 1/4/22. On 9/3/22, petitioner submitted a representation to the NHPC authority for appraisal of DPC that he had successfully undertaken PG diploma course in energy management while in service. Because this became one of the issue because one of the argument that was advanced was that he was not given marks for additional qualification on this count. He
With
submitted
or
it.
without it, he crosses the bar. We have
Even
seen.
then, but I will answer this.
Your DPC
I will
records-
concede. I
your
will concede
DPC
their
record
argument.
shows that the person at serial number 1 who was recommended, petitioner has secured equal or better marks than him.
Yes.
It
Milord,
was only
even-
the
Milord,
only the
even
interview
otherwise,
factor.
I say, finally, Milord, my argument will be, I will concede. They took a very, very technical view because in fact, one of the circular says that you have to submit a certificate of the very course you have passed. Instead of submitting a certificate, he gave the mark sheet. But I would accept that the authorities could have accepted the mark sheet or not to have been hyper technical that since our circular says it has to be the certificate, mark sheet would not do. Even then, Milord, even if he would have got this mark for the additional qualification, he would not have made it for the very simple reason, the necessary qualification, that is getting minimum marks for the interview. That is the essential qualification. You may get 90 marks or you may get 80 marks for total. But if you do not get the qualifying marks in the interview, you would not make it. This is what the policy is. So getting or not getting additional mark did not make any difference. It could have made the difference had he got the qualifying marks in the interview. The additional mark would have pushed him further higher up in the merit. Only that much. But we never came to that stage. But anyway, I'll deal with it. On 10/3/22, petitioner appeared for interview through VC. I don't know, my lord, whether this was argued or not. In fact, but on the last occasion, on an earlier occasion when the arguments were made, this was also one of the ground taken, that he was slightly in a difficult situation because
Appearing in
he
VC.
appeared through VC. But many others also appeared through VC and many of them made it. So that by itself, but I will also, I have touched upon this in my written argument. I don't know whether this was argued on this occasion or not. On 10/3/22, petitioner appeared for interview through VC. The DPC judged the suitability of 24 manager civil E5 for promotion to the cadre of senior manager civil E6 and in its minutes dated 15/3/22 recommended 12 out of 24 manager civil in order of merit for promotion to senior manager civil E6. The name of the petitioner did not figure among these 12 NHPC executives found suitable for promotion. Now, my lord, so far as recommendation is concerned, lordship may kindly look into clause 11 of the promotion policy, because total 24 were called, and as per the policy, only 50% out of 24 they will make it. So total 50%, that is 50% as per the clause 11 of the promotion policy. Lordship will see clause 11, E5 to E6, the chart is given, percentage norms of promotion, so 50%. The total number called, out of that 50% will be promoted.
11.3.
11.1 itself. E5 to E6, 50. Percentage norms for promotion. So 50% of the total number will be promoted. So out of 24, 12 could be promoted. 12 were promoted.
So there are 24 E5 and
Yes.
out of them 12 were promoted to E6.
E6, yes. In terms of clause 11. It is pertinent to mention para 7. It is pertinent to mention that as per clause 11 of the promotion policy, only 50% of the eligible executives could be recommended for promotion by the DPC from E5 to E6, grade in order of merit to be determined on the basis of aggregate marks secured by each eligible executives under various heads. That is power, seniority, qualifications, field posting and interview. 3 separate event dated orders of 29th March 22, all the 12 managers civil were promoted to senior manager civil E5 to E6. So there were 3 separate orders, total 12 were promoted, manager civil. These are annexure 6, 7 and 8 of the writ petition. I believe they are challenging all the 3 orders and making all of them parties. All 3 orders are under challenge, right, Mighty? All 3 orders are under challenge. On being agreed by the denial of promotion to him, the petitioner preferred WPC such and such, assailing the 3 separate orders of promotion dated 29/3/22, that is 6, 7 and 8 of respondent 5 to 16, total 12 private respondents. Additionally, petitioner also prayed for constitution of review DPC to reconsider the promotion of private respondents and fresh consideration of the petitioner for promotion. Further, the petitioner also prayed for a positive direction in his favor to promote him to the post of senior manager civil with effect from 1/4/22 with all consequential benefits. Since, my lord, I have already referred to, so this is what the facts are broadly. I have already referred to the relevant causes for promotion, so I will skip that off. I will not deal with it. I will take, my lord, straight away. My lord, lordship may turn to internal page 4 of the written argument. Internal page 4. Under the heading marks awarded to the petitioner under various heads as per policy.
That is
I will
5,
show, yes,
page 5.
yes. Here, my lord, my copy is old copy. So, and since underlinings are there, so I am referring to it.
No issues.
Marks awarded to the petitioner under various heads as per policy. Now, lordship may verify these facts, my lord, from the records that I have given to your lordship. In the record, my lord will find this here. Proposal for constitution, yes. That is, my lord, the proceedings for DPC. Here, my lord will find. No. Yes. Lordship, the breakup. Here, the breakup. All the marks breakup, my lord will find here. Anyway, I'm just referring to the write-up itself. Side by side, my lord may have a glance at this. So far as, my lord, this is concerned, here, my lord will find the name of the petitioner, the, my lord, record that I have given, the breakup and everything, showing all the persons. The name of the petitioner, my lord, will find here in the breakup at serial number 11, the page number 3. Page number 3, my lord, here. Serial number 11.
Yes.
My lord will notice the total marks scored by the petitioner are 72. Total marks 72. So far as the interview is concerned, out of 15, he got 6 marks. Seniority, he got 0. Naturally, my lord, he could not have got any mark because the date
That
on
is
which
that is the year. Fine.
he could not have got any. Then additional qualification, total marks 5. He could not get any mark. This is one of the grievance, and I will deal with it. They did not give him any mark for additional qualification. Total marks 5.
You have said that because he did not give this certificate.
Yeah, all right.
it was
But I'm,
required by the order.
I'm showing the facts to your lordship, the factual position. Total marks 5 in the additional qualification, he got 0. No marks given. Then, my lord, comes location weightage. Location weightage, total marks 10. He got 10 out of 10 location weightage because he had undergone required field postings. He got full marks for location weightage. Then total par marks. Par, my lord, total marks are 60. Out of 60, petitioner got 56. So, my lord, when it comes to institutional bias, it's a fair reflection on the institutional bias. Par, you are getting 56 out of 60 because your ranking is good. Where is the institutional bias? The problem is how do you perform when you come before the interview board? What do you do over there?
Whatever was done practically for the institution,
Yes,
which reflected his daily work,
yes,
and he failed to perform before the.
that's it. In those parameters, they are wherever, my lord, he was entitled for marks, he got the marks. So, my lord, total marks 72. Merit is fairly high. No difficulty. So this is the breakup. Now, my lord, will turn to my write-up. I have explained this. Under the heading marks awarded to the petitioner under various heads as per policy. 1. Higher qualification, additional qualification. Clause 8.1, total marks 5. Note, since in course of service, the petitioner had successfully undertaken a PG diploma course in energy management, in terms of this clause, he was entitled to maximum 1 mark. My lord, as per clause 8.1, Lordship will just kindly turn to clause 8.1 of the promotion policy. 8.1. In order to encourage employees to acquire higher educational qualifications leading to improved performance, maximum up to 5 marks shall be awarded for promotion from E2 to E3 and above on the following manner. 1 mark each for additional degree, diploma, minimum duration of 1 year, such and such. So 1 mark each.
So since it has now boiled down to the issue
Yes.
that with or without the additional marks given to him,
It would have been
he
no
had
difference.
crossed the bar.
Yes, yes, yes.
The additional mark would have taken him somewhere up above in the merit list, perhaps.
1 mark
But-
additional out of 72.
With or
instead
without
of-
that.
Yes, yes.
With or without that,
Yes.
without.
Instead of 72, he would have got 73.
We just need to now understand
Interview.
whether there was a biasness or an arbitrariness in the interview or not.
Yes.
And having promoted
Yes.
persons who were given that particular leverage of not having field service, was it incumbent upon the respondent authorities to have given the mandatory
Yes,
field
yes.
service to them, not giving that mandatory part to them?
Yes.
Would it convince the court enough to come to a conclusion that these particular persons were the persons who were being given a slight leverage over
Yes,
the
that's
other,
correct.
to have them promoted yet retain them in the office?
Yes.
Would that reflect any bias on the part of the respondents?
My lord got the
so,
core of the issue.
Matter ends.
My lord got
And
the
if
core
you are
of the issue.
convinced that the evaluation by the DPC during the interview does not require an interference, then even if they are kept in the office, no problem. They'll be sent to 2-3 days
So lordship
later,
got
or
Ah.
their retention in the office can be interfered with, directing them to be sent to the field offices immediately.
So lordship got the core of the issue. This is the
Rest of
core.
the arguments
This is
are just
correct.
here and there.
So now I will skip this also.
Ah,
I'll skip this
Yes.
portion.
Whether a certificate.
Now I come to
will come later.
now straight away. So summary of marks and everything, my lord. I just
how
wanted
was
to
the
know.
marks? How was the marks determined?
Yes.
Was
No,
it by the
lordship-
same set of
Correct.
persons for all the candidates? Was it 3 out of 6 for different candidates? Whether the evaluation that took place went out of the 12 criteria that you had given us, since the marks are 12, somehow we are inclined to also think that these 12 would be carrying 1 mark each. When everything else remains the same, how does it come below that is what you need to
The
explain.
doubt in the mind of your lordship is, since there are 12 parameters,
One part of it.
how there is a subdivision, whether there is any subdivision of marks.
Should there
Whether,
have been, could
yes,
there
yes,
have
I
been
will
was
answer it. I will answer it. Now, straight away, my lord, I come to the issue of awarding of marks in the interview.
Hmm.
The parameters, subdivision, whether required or not required, the principles of law governing the field.
That's it.
Lordship may turn to my written argument under the heading contentions made on behalf of the petitioner.
Yes, we were reading that.
So their contentions are there. I will
Then
skip that also.
submissions against was what we were reading.
Yes, all the points I have covered. Now, straight away, my lord, A, because I think it is A which is very much disturbing your lordship. Namely, the contention number A is interview board arbitrarily awarded marks and did not record reasons. All the 12 executives in the cadre of manager civil who did not qualify in the interview were given 6 marks, which reflect arbitrariness and lack of objectivity. DPC also erred in not awarding marks separately under different heads. So 12 parameters, total marks 15. There has to be some kind of subdivision. This was argued. 1 point. The second point was no reason. The third point was all those who did not make it, in the interview, they all got 6. They all got 6. They believe the 12% got 6. It is a different matter, though out of the 12, only 1 came before the Honorable Court. But they are trying to latch on to the very fact that 12 who did not make it in the interview, they all got equal marks. Now, I will deal with each of this. Now, my arguments. Submissions in respect of A. It begins from page 9, I suppose. Para 1, clause 10.5 of the promotion policy provides that the DPC shall interview with a view to ascertain the suitability of the executives for the next higher position and lays down the various parameters on the basis of which DPC shall award marks. These parameters are educational qualification, consistency in performance, professional knowledge, ability to reason out logically, presentation of ideas coherently, environmental awareness, leadership potential for decision making, communication skills, sense of involvement, commitment to the organization, recognition, appreciation letter of director CMD for commendable performance, warning, caution letter issued by the disciplinary authority. It is therefore seen that the purpose of holding interview is with a view to ascertain the suitability for the next higher position. In other words, suitability is an essential prerequisite for promotion, and the same is determined on the basis of performance in interview. And performance is judged on the touchstone of various parameters as indicated above. Clause 4.7 of the promotion policy provides that promotion shall be based on eligibility and merit subject to suitability. The eligibility for promotion is provided by clause 8 of the promotion policy, according to which the qualifying period of service, such and such, I'll skip off. Well, not all this I will skip. Now, para 3, my lord, of this submission under category A, para 3 onwards. In para 19, para 3,
Yes.
in para 19, page 237 of its affidavit in opposition, it is the categorical stand of NHPC that the DPC followed all the 12 parameters indicated in clause 10.5 of the promotion policy, and that the questions were asked, by the members of the DPC keeping in mind the 12 parameters indicated in clause 10.5. In page 254 of its AIO, the NHPC has taken a stand that separate marks are not required to be awarded against each of the 12 parameters, and that members of the DPC are not required to record their marks individually in their separate sheets against each of the parameters. Meaning thereby, the marks DPC members did not award individually for the interview in the separate sheet. It is the unanimity. Collectively, they discussed and awarded marks. I'll deal with this aspect, whether it is essential or not. The NHPC has also denied that the total marks awarded by each of the members are required to be averaged to reach the final awarded marks in the interview, because that is not the promotion policy. There is no such thing. The stand of the NHPC is that the marks were awarded by the DPC after deliberations between the members and with the consent of all the members of the committee. So there was a unanimity. They take the interview, they're all sitting together. They take the interview. After interview, the person leaves, they discuss and unanimously decide he is entitled to this much. This is how they did. No separate marks were given by the members. The NHPC has also reiterated this stand in para 13 at page 244 of the IU. So this is our stand. Now, my lord, I will justify this stand with the help of the principles of law and the propositions and the authorities. The authorities I have discussed from para 4 onwards on the subject.
Yes.
Yes, para 4. The principle of law is well settled that if the rules are silent, because rules are silent here, my lord, rules do not specifically say that the marks have to be subdivided, separately awarded, etc., etc. The principle of law is well settled that if the rules are silent, the selection committee is not required to record reasons for selection or non-selection of a person. Same principle is applicable with regard to marks awarded for interview. If rules are silent, no reason is required to be recorded. The reference is made to Milord National Institute of Mental Health and Neurosciences versus K. Kalyan Raman, 92 supply to SEC 481. The relevant paragraph, paragraph 7 and paragraph 8. I'll just read these two paragraphs
You were reading paragraph 6.
of the. I'm reading paragraph 4 of my write-up.
Oh.
Para 4 under capital A,
Mhm.
answer to the capital A submission. Arbitrariness in awarding of marks.
No, we noticed
reliance,
the
yes.
judgment given at paragraph 6
Ah.
as Madan Lal, the top lines being.
Oh,
just-
my lord had gone into that.
So I went to 6. Good.
Very well. So, my lord, the first citation is the National Institute of Mental Health and Neurosciences versus K. Kalyana Raman, 92 supply to SSC 481. Function of the selection committee is neither judicial nor adjudicatory. It is purely administrative. The High Court seems to be in error in stating that the selection committee ought to have given some reasons for preferring such and such as against the other candidate. The selection has been made by the assessment of relative merits of rival candidates determined in the course of the interview of candidates possessing the required eligibility. So it is in course of the interview, my lord, the assessment of relative merits are being made by the members. There is no rule or regulation brought to our notice requiring the selection committee to record reasons. In the absence of any such legal requirement, the selection made without recording reasons cannot be found fault with. Administrative authority is under no legal obligation to record reasons in support of its decision. Indeed, even the principles of natural justice do not require an administrative authority or a selection committee or an examiner to record reasons for the selection or non-selection of a person in the absence of a statutory requirement. This principle has been stated by this court in R.S. Das. That's the Constitution bench. R.S. Das versus Union of India, in which Kapoor case was also distinguished. Refer para 7, page 484, 485. The relevant portions I have cited. Then paragraph 8. Giving of reasons for decision in different form. Giving of reasons for decision is different from and in principle distinct from the requirements of procedural fairness. The procedural fairness is the main requirement in the administrative action. The fairness or fair procedure in the administrative action ought to be observed. The selection committee cannot be an exception to this principle. It must take a decision reasonably without being guided by extraneous or irrelevant consideration. But there is nothing on record to suggest that the selection committee did anything to the contrary. It should not be lost sight that the selection committee consisted of experts in the subject for selection. They were men of high status and also of unquestionable impartiality. The court should be slow to interfere with their opinion. Now, my lord, pausing here, I submit, it has not been argued. No bias has been attributed individually to any member. Or collectively, my lord, bias has not been alleged against the members of the DPC. Now, my lord, number two, the rules are silent. When there is no statutory requirement, when the policy doesn't talk about it, why should the DPC give reasons? This is the basic argument we have made. In the present case, there was no requirement under promotion policy mandating the disclosure of reasons for the marks awarded in the interview. And as such, the marks awarded by the DPC were in accordance with the promotion policy and rules for NHPC executives. The principle of law is also well settled that if the rules are silent, then the selection committee is not required to give separate marks for various parameters on the basis of which suitability of executives for promotion is to be decided. In this connection, reference is made to Madan Lal. That Madan Lal, my lord, was referring to. There are two paragraphs which are relevant, my lord, 1995, 3 SCC 486, para 13 and 14. I don't know whether the list of books was given or not given, but para 13, my lord, I have.
The judgments here, the stack of judgments given.
Very
So there's no difficulty. We can just go through the.
Para 13 and para 14. My lord,
Yes.
I'll just read these two paragraphs. 486. my lord will find paragraph 13 at page 494 in the Madan Lal case. Now here, my lord, there were 5 categories. 5 categories. Sports of National Cadet Corps activities, 2 extracurricular special services, general physical condition and endurance, general ability and aptitude. Now how the court dealt with it? It is not possible to agree with this contention. Actually, my lord, better we turn to from para 12. Para 12 I'll start first. So far as the first contention is concerned, para 12 at page 493. So far as the first contention is concerned, Learned Senior Counsel for the petitioner submitted that Rule 10 of the rules lays down that the examination for selection of candidates shall consist of written examination as well as viva voce test. So far as written examination is concerned, it is not challenged before as noted earlier. So far as viva voce test is concerned, Rule 10(1)(b) lays down as under. The object of viva voce examination is to assess the candidate's intelligence, general knowledge, personality, aptitude, and suitability, quote unquote. Now, we're not pausing here. Lordship may just consider the difference between this viva voce test here in the Madan Lal case and the viva voce test in our case. Here, my lord, there are total intelligence, general knowledge, personality, aptitude, and suitability, 5 parameters. Here, there are 5 parameters, in our case, 12 parameters. But here, my lord, all the 5 parameters are such that element of subjectivity is involved when you ask questions and the kind of answers which are given. The Learned Senior Counsel for petitioner submitted that when a candidate is orally interviewed, the members of the committee should assign separate marks for the different faculties of the candidate concerned, namely intelligence, general knowledge, etc., as laid down in the rule, and that does not appear to have been done by the interview committee, and hence the entire viva voce test is vitiated. In this connection, reliance was placed on the decision of this court in minor A, Periyakkarupam, was the state of Tamil Nadu. My lord, same is the argument here. Exactly the same argument has been made before a lordship. Now, how the Supreme Court dealt with it? It is not possible to agree with this contention, Supreme Court says. It is not possible to agree with this contention. So far as Rule 10(1)(b) is concerned, it doesn't provide for any separate assessment of marks for candidates at viva voce examination faculty-wise. Same is the case here. The 10.5 doesn't provide for it. That is on intelligence, general knowledge, etc., listed in the said rule. On the contrary, it appears that as per the said rule, while conducting viva voce examination, the committee has to keep in view the main object of assessing such candidates in the light of guidelines given therein. In other words, the interviewing committee has to keep in view the overall performance of the candidate at the oral interview, and while doing so, their intelligence, general knowledge, personality, aptitude, and suitability have to be kept in the center. Now, my lord, the para 14, lordship may have a look at placitum C. Para 14 at page 495, placitum C. A student, whether my lord has got it. Placitum C towards the right, a student.
While undertaking study is not.
A student while undertaking study is not required to perform any duty of public office. But in the case of recruitment to the post of Munsif, he is required to work at the grassroots level of state judiciary. For candidates aspiring to be appointed in such a judicial office, apart from the written test, his overall performance at the oral interview is more important, and consequently, the split up of marks under various subheads at oral interview of such a candidate may not be strictly necessary unless the consent rule regulating such a viva voce test expressly provides to that effect. This is what the court said. Then placitum E. It is stated, not placitum E. It is stated by her that the only considerations which the members of the interview board had during the viva voce test were to judge the candidates on the basis of their intelligence, general knowledge, personality, aptitude, and suitability, as required by rule such and such of the recruitment rules, that all the questions directed at the candidates in the viva voce test were with this object in view, and the assessment has been made of the candidates at the viva voce test accordingly. My lord, this is our case also. The members kept in mind the 12 parameters and asked questions to the petitioner. And accordingly, my lord, taking an overall picture, unanimously they awarded the marks after consulting with each other. Then, my lord, paragraph 7 of my written submission. An identical contention concerning viva voce test conducted by the interview board, which had not subdivided the total marks into subheads, was rejected in Keshav Ram Pal versus UP Higher Education Service Commission, Allahabad, 1986, 1 SCC 671. The Supreme Court observed that the interview board was not under any obligation to subdivide the marks under various heads. My lord, it is paragraph 3 at page 675. My lord, same principle, same proposition, more or less the same, my lord, principle of law stated by the Supreme Court. If my lord desires, I may read it or I may skip it off. Very well. It is submitted that in the present case, the promotion policy, that is para 8 I am reading. It is submitted that in the present case, the promotion policy and the rules for NSPC executives only indicates the criteria to be considered in the interview test without dividing the interview test into distinct sub-tests. Therefore, the DPC was under no legal obligation to subdivide the marks under various heads. In this connection, reference is made to Leeladhar with State of Rajasthan, 81-4 SCC 159, page 166, paragraph 5 and 8, my lord. The same principle again, restated in Leeladhar. Para 9, the principle of law is also well settled that there is a presumption that selection committee has acted fairly. When a selection committee recommends selection of a person, the same cannot be presumed to have been done in a mechanical manner in absence of any allegation of favoritism or bias. Now, my lord, placing reliance on the barium chemicals, the argument was made that malafide is something which can't be seen also at times. But, my lord, again, the barium chemical, the Supreme Court also said there has to be tangible evidence. The word tangible has been used by the Supreme Court, the larger bench in the barium chemicals, the majority of the judges. Unless and until there is some tangible material to allege malafide, and you simply throw in the air this kind of an argument of malafide, it would not stick. Here, my lord, there is no material whatsoever, nothing tangible on paper, on record, to support the allegation of malafide. The same cannot be presumed to have been done in a mechanical manner in absence of any allegation of favoritism or bias. A presumption arises in regard to the correctness of the official act. The party who makes any allegation of bias or favoritism is required to prove the same. In this connection, reference is made to Union of India versus Bikash Kumar, 2006, 8 SCC, 192, page 195, para 14. I'll skip it, my lord. The entire quotation is there in paragraph 14. Since citation is given, paragraph is cited. In the present case, though the petitioner has made an allegation of bias and favoritism, but he has miserably failed to establish the same. Moreover, no bias has been alleged against any named individual. They talk about institutional bias. Now, the argument of institutional bias, my lord, I have nipped that in the very bud. I have nipped that in the bud in the very beginning itself. And, my lord, the manner in which the entire selection was carried out, my lord would not find that institutional bias. He scored 56 out of 60 in the PAR. Reporting authority.
Institution by the institutional bias, is it the, did he argue the bias of the NHPC as a whole or of the DPC
My lord, I take
as
it.
an institution?
Lord, institutional bias would mean bias of NHPC. Look here, the way they are treating this man. Otherwise, my lord, institutional bias cannot be the bias of an DPC. It has to be the DPC, my lord. Then you allege bias against the DPC. DPC was biased. Where is that allegation? And where is the tangible material to suggest and demonstrate that very kind of a bias? What for?
That we will look.
And individually, my lord, nothing particular has been alleged against any member whatsoever. Nothing. It is not the case that he had animosity with particular member did not like him, that he had some kind of something happened with particular member at some point of time. It is not anybody's case. In the present case, though the petitioner has made an allegation of bias and favoritism, but he has miserably failed to establish the same. Moreover, no bias has been alleged against any named individual. The DPC in the present case was comprised of 5 senior officers of NHPC and 1 independent expert from an outside agency. There is no material to indicate any bias against such senior officers. It was also contended by the petitioner that 12 executives out of 24 who had not qualified in the interview had all scored 6 marks each. Now, this is an important point he has made, my lord. That look, out of 24, 12 made it. 12 did not make it. All those who are not making it, all of them are getting 6. This is one argument. That it can't be. That shows, my lord, absolute arbitrariness or mechanical approach. My lord, I have dealt with it like this. I'm reading
The
it.
argument given here is by your written argument is someone got 1 and someone got 7. Both 6 so that one does not feel I'll miss it by 1 and one does not
My
feel
lord,
that I got only 1.
Put it this way. My lord, 5 or 6 sitting over here, we are interviewing a
So
person.
therefore, at least
We
at least
come
the
to
marks-
conclusion, here is a man who makes it.
the marks which have been given to the persons who could not make the qualifying marks, at least while reflecting it in that sheet where the marks are given, the actual assessment has not been given is now admitted.
Yes.
It was something to show.
I'll explain.
So therefore, the assessment sheet given to us does not reflect the actual assessment of the petitioner. The records
No,
do
I'm-
not, sir, let us not go for
Very good.
arguments for arguments. We are also running short of time. By admitting that part of it, the 6 marks given to the petitioner, now this court does not know, nor anyone who would look into those records thereafter ever know whether he secured 7.9 or he secured 1. Therefore, the submissions of the DPC that 6 was scored by him goes. When
I'll
6
answer it.
goes, we do not know on what basis what mark he has been given, nothing on record to show. And therefore, that assessment has,
Yes. Now I answer this. The answer is twofold.
where otherwise, if this kind of assessment reflecting in records is allowed, tomorrow everybody who cannot pass the matriculation examination will have 22 marks. Whether he secured 0 or 29, and everybody who passed would only be assessed.
My lord, I'll
So
answer.
therefore, the intention was disqualified, qualified, disqualified all 6. That minute it goes, sir.
No answer. First of all, my lord, the example of
The records
matriculation.
do not reflect,
All right, yes.
signed records do not reflect
My lord is
the
100%
actual
correct.
assessment,
Records does not reflect.
the
No,
actual
my
assessment.
lord, let me answer it. I'll put it this way. I would rather say records reflect the assessment of records reflect the assessment in terms of suitability of an individual.
That
The
everybody had
assessment is of the assessment is of a suitability. I'm answering it. The assessment is of a suitability.
Ah.
As to whether a person is suitable for particular post or whether a person is not suitable for that
So
post.
therefore,
The suitability is to be judged by virtue of an interview.
therefore, by the same logic, a person found suitable would be given just enough marks for him to qualify.
Oh, yes. But
Then this record does not reflect the assessment, sir.
My lord, I'm coming to that. My lord, there are 2 ways. There are 2 ways. The 6 marks are equally allotted to all those who could not make it. But so far as
Why not allowed 8 to every man who made it? Why not allowed 9 to every man who made it?
that's why I'm answering. My lord, my lord, let me answer it.
Our
The
apologies.
moment
Please do.
the answer is the moment board finds a particular person suitable by taking in the interview, immediately the merit comes into play. Because the moment we find a person suitable, when we give him the marks, keeping in mind his suitability for the interview, we know very well here is a person who will be among the first 12 to get the promotion. So inter se merit will come into play. It's a very, very important aspect. Inter se merit will come into play 1 and 12. 1 to 12. But the moment, my lord, this is, now look into the other part. The moment board comes to the conclusion, here is a person who is not suitable according to us for the particular promotion. My lord, let me answer. The moment board comes to the conclusion that the person is not suitable for promotion, then the question of merit doesn't arise. He is not making it. Once he is not making it, well, we give him this mark. It doesn't matter. Because the question of merit doesn't arise over here. When it comes to merit, my lord, marks become very relevant. So when we talk about the actual assessment is the assessment of suitability. Whether you are suitable or you are not suitable. Once you are suitable, the question of overall merit comes in. Once you are held not suitable, the question of merit doesn't come in. Inter se merit is not there at all. Because in inter se merit, my lord, is the promotion. Once you are promoted to the higher post, the seniority list has to be prepared. That is why, my lord, each and every single mark above the 8 or 8 and above will become very, very relevant. So we have to be very careful. The moment we come to the conclusion, a person is suitable. The moment we come to the conclusion he is suitable, oh, now the merit of, he is coming into 12, who are making it, inter se merit will come into play. So now whether he is 8, whether it should be 9, whether it should be 10 or 11, we will decide. That is why my lord will find mark 8 and above, there is a variation. But there is no variation when it is below 8. This is the answer. And my lord, this is the most reasonable answer.
Yes.
So, my lord, a bit, because once the overall conclusion is a man is not suitable.
No,
He-
that
bas.
point understood.
Bas, that's
Understood
it.
that point. We don't need a repetition.
Then, my lord, the next. B. Marks scored in par ought to have been the basis for giving marks in interview.
Hmm.
The very scheme of the promotion policy makes it evident that the interview served two different purposes. First, the marks scored in interview, along with the marks scored under other heads like par, field exposure, seniority, and additional qualification, determined the overall merit of the petitioner. However, suitability for the promotion was to be determined only by way of interview. Though the suitability is one of the components of merit, but the assessment of suitability is only by way of interview. So, my lord, suitability is only one of the component of merit. Merit has so many other
Were
components.
the interviews held on the same day, sir? All the
Uh,
interviews?
Interview, my lord, not on the same day, possibly
Different
different
day.
dates, but members were the same.
Ah,
Members were the same. But I'll verify this fact, my lord, before confirming it, whether same day or other dates.
perhaps let's find out whether
I'll-
it was on the same date
Huh?
or different date.
On, my lord, dates,
Different.
more than one date. So, my lord, actually, this is important
Hmm.
because this has connection also with the earlier answer I gave, assessment of suitability. Or why all of them 6? The suitability for the promotion was to be determined only by way of interview. Though the suitability is one of the component of merit, but the assessment of suitability is only by way of interview. So, my lord, merit has so many components.
Hmm.
Merit has so many components: seniority, suitability, par, field exposure, etc., etc. But suitability is only by way of interview. So that is why, while answering the earlier question, I said, since suitability is only by way of interview, the moment I find a person suitable, merit question arises. I have to be very, very careful.
All the APRs were before the
Oh yes, all the parts. All the parts were there. So here, my lord, only suitability. Hence, marks scored in the par could not be taken into consideration for determining the suitability for promotion, but had relevance for determining the overall merit. Now, my lord, pausing here, I just put it this way. My lord, if par is to be made a basis, my lord, I ask myself, if par is to be made a basis,
DPC.
why DPC? Correct. Let us have a computer, put it, the par, see the gradings and finish it up. Now, my lord, I come to the composition of DPC. I think composition is one of the argument, but I think I have clarified this. Should I have clarified, but anyway, I have dealt with it in C.
Ah,
So entire thing has been, I have referring to the records, I have shown how the members were brought in, because initially composition was different. Somebody got retired, somebody was posted elsewhere, somebody was not available. So on each occasion, we carried out the whole process, and the relevant portions I have shown, my lord. So should I read it or explain it? It's not needed. Very well. Then now I come to the most important aspect, my lord, the second aspect, where my lord was slightly doubtful, namely the field exposure. How marks were given?
Field
Because
exposure where where they did not have field exposure, no marks
Yes.
were given.
yes,
The issue was if someone without a field exposure was supposed to have been given
so I'm dealing with it.
promotion, he was required to have been
Yes.
sent for a location.
Yes, yes,
Your reply is that due to service exigencies requirement of the office work,
yes.
everybody could not have been sent at the same time. It like
We followed
discretion.
policy and they were made to, because that is why we have done. Let
They
me
were
just-
they were sent for field
let me explain
Of-
this,
yes,
how
sir.
it was done.
was done.
That is D, internal page D,
Uh,
D of my written submission.
uh,
Total 6 managers civil, respondent number 5, 6, 7, 8, 9, and 12 were promoted from E5 to E6, even though they did not fulfill the requirement of requisite field exposure of minimum 4 years at the level of E2 to E5 as prescribed in clause 12.82 of the promotion policy. Clause 12.8 of the promotion policy carves out an exception to the requirement of having minimum 4 years field experience at the level of below. Let us turn to 12.8 first.
6, 7, and 9 were sent. 5 was not sent. What happened to 8?
In the present case, respondent 5, Shri Manoj Kumar,
He
on
was
his promotion
retained.
to E6.
He was
6, 7,
retained.
9.
6, 7, 9 was sent. 8 and 12 are
Similarly,
Okay.
the para 4.
Uh-huh.
Similarly, respondents 8 and 12
Ah,
are also in field posting in terms of first para of clause 12.8 of the promotion.
can we
policy.
just have somewhere in your affidavit as to when was 6, 7, 8, 9, and 12? Perhaps Mr. Gogo can help you.
Because I think it
6,
came out
7,
in the
9, 8, 12. When were they sent on their field postings? After how long
6, 7, 8,
of
and
their promotion? After how long of their promotions have they been sent? That
My lord, I'll just take a minute. I'll show.
we can
Page,
proceed. He can find out
page
the-
AI affidavit in opposition. Let me just have a look. Or is it in the reply? Otherwise, I will get records on that. Just a minute,
No, we
please.
just need the dates.
I'll look into that. Your affidavit. See, and give me. No. Hold on. Oh. 64 to 65.
Posting R3.
R2
R3.
or yes,
Page 266.
yes, my lord.
Yes.
Different dates are given.
Which are the
1, 2, 3, 4, 5, 6. I find details of 6
3,
individuals.
4, 5, and 6 persons.
6 and just a minute.
Yes, they were promoted on 2022. So in your write-up, you have said 6 was sent. 6 should be sent on April 22. He was sent.
Yes.
7 April 22, 9 April 22, and 8.
8, my lord.
8, when did he go?
8 is
Chenab
respondent.
Valley's way.
See the name of respondent 8. Ranveer Singh Rawat.
Chenab Valley, when did he go on the field posting?
I'll find out. I'll just Ranveer Singh Rawat. Ranveer Singh Ravina Kumar Chaube.
And 12, when did he go?
Ranveer
So,
Singh
sir, if you see at serial number 8, Dhanvir Singh Rawat,
Rawat.
the last column, page 266, sir. The last
Why-
posting shown is on 05. The serial number is 05 on the last column of page 266. He continued, yes,
266 is not, yes,
annexure R3
yes, R3, but Dharmir Singh Rawat may not,
is at serial number 8.
something is actually.
Then it is Chenab Valley from
May
October
not, may I
20
may I
to
take that
November
help?
20.
May I take that help?
Something wrong here.
8 to 12, see the name. Dharmir Singh.
12, he
When
has
was this?
remained in Subansiri HEP from 17 to
Lord,
November.
may I give the date of 8 to 12, my lord?
Ah,
I'll
will
just
you-
take down from the records.
Because it is not there in the affidavit.
yes, that is
It
fine,
is
my
not
lord,
there
it's
in the
missing.
argument.
It's there in the records. 8, 9, 10, 11, 12. All dates. Have you? has he
And
understood
5
the-
never went for a field posting till date.
Yes.
5 never went.
No, sorry, I'll just, yes.
5 has never.
Present
got a
case,
field posting.
respondent 5 Manoj Kumar was promotion to EC was
Mhm.
retained in the corporate office with the approval of the competent authority in terms of third para to clause 12.8 of the policy. Yes, he
So
did
that
not.
part of
because
the
it's-
policy has been violated for 5, for
No,
8 and 12
violated.
as of today.
I-
With due approval
yeah.
from the competent authority, but the policy has been violated. Policy does not
Policy
allow
permits this.
the retention.
That's-
Kindly show us the retention.
That's why, let me turn to
The policy-
12.8. That's why I wanted to go through the promotion policy.
Yes.
12.8.
মিনিট এইখন গুচাব লাগে জানেনে এইখন গুচালে মই কাগজবিলাক বিচাৰি নাপাওঁ তলত থলো নে ওপৰত থলো হ'ব দিয়ক লাঞ্চত গুচাই দিম
12.8
yes.
of promotion policy.
Oh, yes.
There are 3 categories. After the heading, my lord, after the chart, field, how much of field exposure is necessary, my lord will find the 3 separate subdivisions. Number 1, I read all the 3. 12.8. The third one, where the executive does not have sufficient exposure at the time of consideration
the
of
last
promotion.
paragraph
The
that
last
said-
one to counter. This is the answer. To counter operational difficulties in implementing the clause
So
relating to field exposure. So here, my lord,
5 is a person who can never be sent to the field.
can, but since at the relevant point of time, CMD needed for, there was a requirement, operational requirement. So the CMD allowed that. And the policy
The
permits
CMD
it.
who has now perhaps retired immediately after the promotion.
But these details, again, I have to assert it. But
That-
the
that
CMD,
was-
new
that was
CMD
one
has
of the-
come.
That was one of the allegations in the writ petition that the CMD almost retiring on the verge of retirement had got everything done. So whether this retention allowed immediately prior to his retirement, being allowed to continue till now
You know, that
in
would be-
violation of that
would be
particular.
too far-fetched an argument now.
It
The
will
only
be
thing
far-
to be, I'll put it this way. The only thing to be seen is at the
Immediately
relevant
cons-
point of time, when the promotion was being considered, how the promotion policy was adhered to. Whether there was any violation of law, as to what was there behind,
That
which
retention
was,
order we would require, is it on record?
in
R2,
the case of
Mr. Manoj Kumar.
Manoj Kumar,
Ah.
R5. R5, I think, my lord, the one. Huh? R5, the one I had,
Page 265.
What is the EMS division?
Estate management service,
Huh?
estate management,
Estate Management Services.
like what you have.
no, my lord also may have a look, E5.
Well, point it is for such key functions such as design and engineering division.
Uh-huh.
12.8 says to counter exigencies.
We just asked you what is EMS division? We will stick to that for the moment. You would have your option to
Lordship.
opportunity to reply to his order. Okay.
Lordship, may kindly, one more thing.
Yes,
May I point out
please.
regarding that also, the last one which your Lordship read, I may also kindly, again, the exact language is to counter operational difficulties in implementing the clause relating to field exposure for few key functions such as design and engineering division, company secretariat, cadre, etc. It is etc. Exceptions, if required, may be made after approval of CMD by recording proper reasons. So it is not exhaustive. Primarily, what is to be seen is whether the person concerned is involved in some key function at a particular point of time in the organization.
Hmm.
And if the CMD deems it fit,
Recording
proper reasons may act accordingly. So, my lord, if need be, I'll produce relevant records on that. What was? Where are they? So, my lord, those things I will also give.
His services are essentially required in the EMS division. That is the estate management division.
Ah.
That is the justification given. We will not go into the other justification. The justification is EMS division, the estate management services.
My
That
lord,
was the
there is the
justification
clause.
given at page 264.
Yes.
The justification
Ah.
that was taken into consideration. We are just looking into that, so we are
Very
not
well,
doing
very well.
anything adverse or.
But so far as the clause is concerned, the clause talks about
anything
design,
extra,
engineering,
ETC would, whatever ETC can cover.
and CMD in a given, because in an organization, at a given point of time, there may be contingencies at times are such. We can't really identify contingency in a particular manner. That contingency has to be only A and B type, not of X and Y type. But sum and substance may not, reasons have to be given by the CMD. Why that is not being done. So exception was made in one case. Exception was made in one case. And thereafter as to what happened later on, because the new CMD came and what is the present status, I don't know. But I'm only concerned at the relevant point of time, whether the promotion policy was adhered to or not.
Lordship also,
The very inception, how the promotions were made at the initial stage. What happens thereafter is immaterial, my lord, is insignificant.
so I've also been 100% been confirmed, Lordship. EMS stands for Estate Management. Service.
Estate management. Sir.
Colony and Building Maintenance. Your Lordship.
Thank you. Right, sir.
So, my lord, this is what it is, and I will give the dates in respect of all and
Yes.
the relevant records if anything else.
Yes.
They have gone there, and if there is any, my lord, clarification your lordship requires from my side, I will give that.
Right, sir. This mark part is because the certificate was not given, the additional qualification that he tried to impress upon.
Yes, that I have
The
answered.
mark sheet given,
Even if I concede.
Even if it is accepted still,
Yes.
there'll be nothing. Yes.
Actually, they took a very technical view. I have annexed that circular.
Now, if they go so technical, then you can also go so technical by saying that certificate was not.
But I am not. But I concede.
Because
Even
the-
if, my lord,
the-
even if we would have given one mark, 72 would have become 73.
That is at page 18, para 3, you have stated that.
Yes, and my lord will make kindly, there is, my lord, in fact, there is an office order, 24th of July 2020
Ah.
at para 11. I have annexed it with my written submission.
Okay.
Is it
Sir, give
whether
us
this
2
was the next?
minutes. Give us 2 minutes, we'll be right back.
Very well, very well.
2 minutes. I'll come.
Collectively, the members of the DPC come to a conclusion that the concerned candidate is not suitable or unsuitable, then the matter rests there. It is not being suitable. But the moment person is found suitable, the question of relative merit arises. When a person is found unsuitable, the question of relative merit doesn't arise. So idea is to judge him unsuitable.
Merit will come after he is found suitable. That is your.
Yes. So idea, the moment there is collective decision making, namely Mr. X is not suitable, he is held unsuitable. Give him this much to indicate. So idea is to indicate unsuitability. 6 was a number to indicate unsuitability. But the moment you make it, you get 8. The question of relative merit arises. And then, my lord, we have to be very careful. 8, 9, 10, 11, 12. Then there we break our head. How we judge them. Here he was found unsuitable. So 6 indicated unsuitability.
So that would mean even before the entire interview of a person is completed, halfway through, everybody has a consensus that this man is suitable. Now
After
let us assess them.
the interview is over, we decide, we discuss. This is what our stand is.
But the interview is gone. So after everybody has been interviewed,
No, not
Can you
each
assess-
each person. The moment you interview a person, you discuss collectively.
when the
Suitable, not
discussion is
suitable.
going-
Is not suitable, mark is given indicating unsuitability. 6 is the mark
So
given.
these are the these are the 12 persons we find suitable. Now let us take their merits. We'll give him 12, we'll give him.
No, no, no,
9.
not like that.
When does the
each-
decision of suitable and unsuitable come in?
In course of an interview of each of the candidates
So therefore,
separately.
so therefore, that suitability has to be decided even when the interview is going on
Yes, yes,
collectively.
collectively.
So the candidate sitting there, the decision has to be taken that we find him suitable right now.
Not in the presence of a candidate. He will move out.
Or he will be, you're found suitable, please go outside. Now we'll
No, no, no.
discuss whether you are suitable or not.
Milord, marks are not to be disclosed to the candidate.
We'll have to take a practical approach. So
Milord,
I'm just trying to approach.
yeah.
I may be wrong. I'm just
Milord,
trying to
mark-
approach.
Since, my lord, there is no requirement of disclosing marks to the candidate.
No. Let
Yes.
understand my part also. I'm
Yes.
trying to understand yours.
So
Understand
first
my-
I explain to your lordship, then my lord will ask me a question.
Right.
And then it's better that way.
Yes.
What I have been given to understand, Mr. X walks in. Mr. X is interviewed. Interview over, he goes out. Members, because there is no requirement of disclosing marks to the
Nothing
person
to-
concerned there.
he goes.
So we discuss suitable, not suitable. Not suitable. Well, then in that
Then
case,
the
we give him
chapter
6,
ends.
decided.
Chapter ends.
Ends. 6 given,
Suitable.
over. Y comes in. Interview is done. We are satisfied with him. He leaves. Again, we discuss. Suitable. Then how much should be given? 8, 9, 10. That's how it is. Because then we are very careful about the relative merit.
So therefore, to know the relative merit, you must know the merit of the other person also.
No, at that time, he's good. We give him 9. Somebody else comes. That somebody, after Y, Z comes in. Z also does very well. Whether he did better than Y or whether he did comparatively not better than Y. Well, Y was given 9. If Y, no, he's better than Y, we give him 10. That is how it is.
So the markings was on the basis of his competition with Y, not on his own.
Why, Milord? I
Not on
don't
his
know.
own.
This is, Milord, I guess. This is not evident. Whether
You said you are under instructions.
that is,
Uh,
Milord, I don't know, because on this aspect, Milord, I'll find out from them how
The DPC has to do it, not from them. The person now holding the record would not be able to. say
Actually, it
DPC
is not
did.
how
It will
the,
not
this
be
is
the-
not evident from the, I
It
admit.
will not be the.
I admit, my lord,
It
it
cannot
is
be on
pure,
paper.
I just do not know. One can only hypothesize
Yes.
whether collectively or thereafter, but my submission would be, as to whatever was done, 6 by itself will not indicate arbitrariness, because the question of relative merit is not involved. And since all those getting more than all those scoring qualifying marks in the interview have been awarded separate marks. So therefore, there is no element of arbitrariness. As to what was the methodology adopted, whether it was separately, collectively, later on, or at that very point of time, I do not know, because the records do not reflect it. But that merely a fact that the records do not reflect such a situation would not ipso
That is what
facto
the judgment says.
would not ipso facto would enable my lord to form an opinion of arbitrariness. It is not arbitrary, because promotion policy doesn't talk about recording of reasons. It also doesn't talk about giving of separate marks, dividing it into subdivisions. This is the answer.
Noted.
So, my lord, if any clarification is needed, I will give. Otherwise, my lord, I don't have a right of reply as such thereafter. So,
If we need to understand.
my lord, it's my lord's
if we
discretion
need to
because
understand anything more.
my esteemed colleagues, senior would object to if I say further after their reply. So, subject to my lords seeking a clarification, I will give an answer.
We have seldom seen senior counsel saying that no, he will not reply to what I have
It
said.
has happened. It has happened. It has happened.
No, we have said seldom.
It has happened with me.
Hopefully not. in-
There was vehement objection that after my reply, no further reply. So,
Yes, sir.
Lordship, may I be permitted to reply on 9th, your lordship, Monday?
See, the difficulty is this, the day we start keeping it part-heard,
Lordship.
it's like a meter down. We have a number of days to address.
Okay.
So if it is 9th of March,
No, 9th of February, lordship, Monday.
9th of February,
Monday. So my
10th
senior is
के था
before
तो-
division bench 1, your lordship.
10th केटा আছে সব any indication 10th কেটা দেখুৱাইছে civil 10th civil 10টা we'll try 10th. It's a hearing day.
9th, lordship, 5 minutes.
It's a,
5 minutes, lordship, 9th.
then you will have to bring your alarm clock.
Lordship.
He says 5 minutes on
Lordship.
9th with an
Lordship.
alarm clock. When we keep something part-heard, it becomes difficult for us because
Lordship, I
time for us
understand,
is
lordship,
done.
but I don't want to waste the court's time today, your lordship.
It's not
since-
about wasting our time.
the lordship has seen that. My lord, just
Sentence is a
Lordship,
lordship has seen it.
new learning for us. No
Okay.
difficulty on that, but the days, number of days we are taking to come up with a judgment.
lordship.
My lord, only one thing, though lordship has, I think, already seen it. It is, my lord was asking certain questions about Manoj Kumar.
Hmm.
I think fairly elaborate explanation is given in annexure R2
Yes,
at page 264
yes.
of the paper. That lordship has seen. Because entire thing is, Shri Govardhan
Three-
Thomal
three
is engaged
persons
in
were there.
critical works of cybersecurity and
One
network.
with cabinet affairs,
And,
one with something else.
and then it may not be prudent. So
For
Shri
coordinating-
Manoj Kumar,
Ah,
Shri Manoj Kumar is
EMS
engaged in
division,
critical works
EMS division
of EMS
and
division. on
liaising with
coordinating
the
district
district
authority.
authority.
Yes, yes.
Authorities.
Yes.
And it's that
And
lordship
because
has seen it
the
already.
person
I
has
know.
seen that.
Very
I
critical.
told him, I told him the lordship has seen it.
That's it.
So fairly
I pointed
elaborate.
out 264.
Huh.
I
I
pointed out-
know that. That's why since my London friend was very careful, he was rather enthusiastic. I should point out again. I know lordship has seen it. So fairly elaborate reason is given, my lord. It is not that it was very cryptic and then it was done away
It
with.
is not cryptic, it has reasons.
So that is it. So once reasons are there, my lord, adequacy of the reason or what, that may not be the relevant factor.
The procedure followed and whether there was some
Whether
material.
the promotion policy was followed or not.
whether
I'll
the
put it this way.
Whether the promotion policy has been followed, whether there are reasons for doing what has been done,
Yes.
and whatever has been done, does it fall anywhere within reasonability? There may be other.
Or
reasons.
arbitrariness.
Ah,
There is arbitrariness.
Does it exclude arbitrariness?
Yes.
If it does so, we have nothing to say.
So,
That
yes.
is your argument.
That is writ of certiorari because my lord is in a certiorari jurisdiction.
Hmm.
Certiorari is only when there is error apparent on the face of the record, arbitrary, unreasonable, and total non-application of mind. Or, my lord, deviation from the promotion policy. And the nature of deviation is not mere procedural, but it is substantial,
counts,
which makes the entire process incurably defective
Hmm.
and vitiated. This is what it is.
So the main thing we have to answer is the arbitrariness part of it.
Yes.
The others would be.
The only
But
aspect
if it-
is 6 and above. There my answer is relative merit. Comes in 8+. Here no relative merit is involved. Why should I be careful?
Had he scored 8?
The idea is, look, all you people 12 are unsuitable. You get 6. All of you are unsuitable. That's all. There is no relative merit inter se between the unsuitable ones. Relative merit is only among the suitable ones for the purpose of seniority in promotion. That is the answer.
It is eligibility, comma, merit subject to suitability.
Yes, a suitability to be ascertained through interview. It is
Suitability
policy
by
says so.
interview 12 criteria is given. Those criteria without reference to the API have to be assessed by
Yes.
the DPC.
Yes.
on their interaction with the candidate.
In
and
the form of
therefore they may
opinion.
vary, and vary it has, leading to the heartburn.
That's it. Here, collective decision making is there to rest the all dispute. To practically the idea is to bury the dispute.
Yes.
Because once the variation comes in, deviation comes in, the problem arises. So unanimously they decided this is what we are going to do in each of the cases. That is how it
If it
is.
is one committee, they'll have one decision.
That is it. One decision only.
9th.
9th, Lordship.
Please make it happen on 9th.
It'll happen on 9th, Lordship.
The arguments of Mr. Very learned senior counsel appearing with the assistance of Mr. Gogoi for the respondent NHPC has been concluded. The learned counsel Mr. So-and-so and Gautam has prayed that the matter may be taken up on 9th for reply on behalf of the petitioners. This matter had been kept as part heard on (27/1/2026) full stop. List again on 9th of February 2026 for concluding arguments by learned counsel appearing for the petition.
The private respondents, Lordship, the last occasion, no one appeared.
None have appeared, I don't know.
Mr. Ranjit Hazarika, I was told.
RKD Chaudhary.
RKD, Ranjit,
None
yes,
here.
Ranjit.
None here.
No.
None appeared. The private respondent is what I have to.
I'll tell him.
Because now we have kept it for his
He
reply.
possibly believes that I am there. I have argued for NHPC, so his job is done. He's not required to say anything else.
Or
he was telling me on the earlier occasion.
or that this court may take the whole day to understand.
He says, this is like, I have nothing to add on whatever you will argue. So what do I say?
They would be the best person to have clarified the doubts on the posting of R5, R6,
Correct.
R7,
correct.
R8, R9. whatever.
I'll tell him that. So
That
possibly
particular dates should have been given by him immediately because he would have the clients.
correct.
with him.
Since my lord, on 9th, the matter will be taken up. So I will I will tell Mr. Chaudhary that to look into that aspect and to take necessary instruction from the
Because
clients.
that will again delay the entire thing if he comes back to argue on the
He won't be
9th.
arguing, I don't think, because on the last occasion also he did not argue. He said he has nothing to add on the legal principles and factual part. So practically it's all the matter of record. So whatever NHPC, because they are the beneficiary of the promotion and they don't know really how they were promoted. NHPC knows better. So that is why. But yes, nitty-gritty of it, where are they posted and all that, his clients, he will be able to provide information on that.
If you
He will do that.
chance to meet him, just tell him we need that detail of their posting after their promotion orders.
And 10th has retired, no, respondent number 10 is retired, Your Lordship, in October.
That we will keep down in the order itself. Point it out to us when we take up the matter on the 9th. We will not repair.
Last October.
We will not remember 9th.
Vacancies, the vacancies.
Mr. Chaudhary should know that. I don't know.
So vacancy is there, Lordship.
The vacancy is there.
So vacancy, but you have already been promoted. So possibly he wants to.
No
Post it.
optional.
Post
Acha.
it.
No
Post-
optional.
Post dated.
That is.
Yes.
My lord, the only thing, since my lord, this case has taken almost the first half.
Hmm.
I have got 2 more hearing items before your lordship only today.
Hmm.
So but I don't know, my lord, because one
Well,
is that.
like we said, sir, we are available. And if we cannot reach it today, we'll have to see the date. That is why I have
that
recorded
is
the
why.
date
Because
today.
the other matter, my lord, the last case possibly in course of the day before a lordship is industrial law matter.
Ah.
That by itself will take a very long time. And
Mr.
prior to that, my lord, is this
Number that, land
chapter
matter.
10 matter, land matter. I
Land
have got the instruction.
Ah.
If the matter reaches, I will clarify
All right.
some of the things.
We'll try. Let us go
Very-
item wise. We'll try.
Very,
As many
if
as
it
we
reaches,
can.
yes.
Many as we can. This will be on the 9th. I should be there. Yes,
My lord
sir.
had disposed of a similar matter on the other day. Now that my lord has relied upon Purnabati Brahma's decision. My lord, I'll just make only 2 submissions on that matter. One is, my lord, that judgment did not, my lord, take into account the deeming effect of 2013 regulation, 11 regulation, where there's a deeming provision, where, my lord, which was discussed in Mohor Ali, madam.
No, that
that
Deeming provision.
section 4, my lord, of the 2013 Act. It says, my lord, as on that date, everybody is deemed to be an employee if he fulfills, if the school fulfills the criteria. So that deeming provision has been interpreted into, my lord,
No, there were other judgments whereby the deeming provision, the single bench of this court had held that yes, they would all be deemed to have been provincialized. Those were carried up in appeal, one
my
of
lord,
the
Mohar
appeal
Ali
was
Sheikh, my lord,
dismissed and the others
division
what
bench, my
happened?
My lord, in fact, in one of the coordinate bench judgment, my lord, it has interpreted this, the Dilip Das judgment,
Hmm.
where it has been said that, my lord, the deeming provision will come only when the process under 10-4 is completed in respect
Completed,
of
yes,
yes.
that is what this is.
And
Bihar
until that
judgment
is
and the
done,
other judgment.
and in that context, my lord, the coordinate bench has taken note of the three judges bench of the Supreme Court, my lord, where it is said that once a act is declared to be unconstitutional, it is
No, no,
nonnes
then-
for all purpose.
But then the Mohar Ali Sheikh judgment is also for division bench, which says that there would be a deeming effect.
My lord.
once
But
my lord,
that's
the
my lord,
recommendation is there from the district scrutiny committee, then, my lord, the process has already been initiated as a deeming effect because the act says, my
Now,
lord,
what happens if, suppose the district scrutiny committee plays and it is deemed, and the state level finds it is not, he
but
is not eligible, then what
that,
happens?
that is what is discussed
yes,
in
that
my lord,
is
category.
Mohar Ali. That is discussed in Mohar Ali, my lord.
Huh.
That's, my lord,
It goes up to the government and the government has to say no.
my lord, because, my lord, what has happened, my lord, generally, normally what happens, they have to, the district scrutiny committee or the state level scrutiny committee has to see whether they fulfill the criteria or not.
Ah, yes.
Once the criteria is fulfilled, the government has basically no scope to say no. Because the idea is, it's given in the act. Whatever the parameters are, that's already in the act. If the
So
school
now we'll
fulfills the
require to
criteria,
evaluate Purnabhati Brahma as against Mohar Ali.
Mohar Ali.
Mohar Ali is,
Because Purnabhati Brahma did
Mr.
not discuss this deeming effect.
Mohar Ali is heard, mister.
Yes.
But Mohar Ali, my lord, the deeming clause, my lord, the
What, that exact paragraph can we have of Mohar Ali?
Yes, my lord, paragraph 112, my lord.
that was in the context, my lord, because of section 24 of the new act.
Obviously.
That was in the context of section 24 of the new act,
Ah.
where there is a provision for review.
Review, yes.
Yes. In that context, in Mohar Ali, the division bench has said that once they have accrued a right, their services are provincialized,
Ah.
then we cannot do it.
Ah.
That
Ah,
is in that.
that we cannot do. That is exactly what we are
And
saying.
Purnabhati Brahma is, well, that if it is not provincialized,
If that final stage has not arrived,
not reached,
then the
yes.
provincialization is not there.
Yes.
If it is not there,
In fact, my lord, in the Deepak Kumar Das, my lord, this honorable court, my lord, earlier discussed about the provision of 10-4, my lord.
Kalpana Barua or something was there where Purnabhati Brahma and others were also taken into consideration.
I'll look into that.
Only
Now,
Purnabhati would
there were two judgments, my lord. One was Deepak Das and Dilip Das, my lord. When
Ah.
Dilip Das, my lord, it is said that
there was a litigation in
yes,
one of them.
yes. And in Deepak Das, my lord, it was said that until the provisions of 10-4 is all complied with, my lord,
Ah,
there cannot be a right under section 4. Because section 4 deemed provincialization will come only when it has reached to the stage of issuance of notification.
hmm.
And in Keteke Baremelo, then subsequently in a coordinate bench judgment, will discuss both the judgment
Hmm.
and has held that until 10-4 is fulfilled, my lord, the entire process under 10-4 is completed, there cannot be a right under section 4, my lord.
Paragraph
I also
112, my
got that
lord.
impression. Yes, sir.
112, my lord.
And
Where, my lord, section 3 and 4, my lord, interplay, my lord, has been discussed, my lord.
insulation. Page 100 and
My lord, paragraph 112, my lord.
para 112.
12, my lord. A conjoint, it starts with a conjoint reading of section 3, 1 and 2 and 4, 1
Would
and
be around page what?
in my, my lord, it's a 30 pages, page 37, my lord.
Huh?
37. The 54 pages.
And 12.
Report, it says reporting 24 5 GLT. 24 5 GLT. Exactly.
Yes, what does it say? A conjoint reading of section 3, 1, 2, 4, 1. No room for doubt that there was a deeming provision under section 4 of the repealed act.
Yes.
Eventually described in section 3, whose employees have complete 10 years of without a break from as per section non-teaching employees who had not completed 10 years. those coming under the purview of section 3 would automatically be clothed with the eligibility for their services to be provincialized. Section 5 from the record available could find number of teaching services under them had in reality attend the eligibility this is where the difficulty is. If you come to page 116,
Para 116, madam.
para 116.
Six, yes, madam.
It says, we find that even the District Scrutiny Committee constituted under Section 10 of the Act of 2011 had verified their credentials, whereafter recommendation was also made on Iman in favor of provincialization of their services. Pursuant to such recommendation, these teachers had acquired the status of government employees under the Act of 2011. Now, this does not take into account the situation that they were still some gaps remain to be fulfilled by through a recommendation by the SLSC.
SLC, madam.
If that SLSC has not been dealt with by this judgment,
My lord.
what has already been dealt with by other judgments of this court,
My lord.
until the SLSC is done,
Right.
it is thereafter even your submission
Right.
that the government would have little to do but to issue the
But
notification.
here in my case, well, the SLC had also well recommended.
Even then, the Punabati Brahmo says that unless that order is there,
But the Purnavati Brahmo did not take into effect, well, didn't even discuss this Zimmer. That's the
which
issue. madam.
deeming provision.
No, man, it didn't discuss.
No, deeming provision was,
No, it was-
deeming provision was discussed.
If I'm not wrong, Malad, that's subject to correction. It was not discussed, Malad. It was simply on the line, Malad, that the court said, Malad, in view of Chandan Niyog, we need not go into the intricate details in this regard.
Ah,
Para, Malad, page 3, Malad, paragraph 4. So there, Malad, Chandan Niyog and Malad, the review judgment was
now
taken.
that there is a doubt in your mind that there are judgments of the division bench which may have taken into account the deeming provisionalization.
Well.
Our attention is drawn to section so and so. We remember reading somewhere, not often
To
now.
my knowledge, of course, Malad, I've not come across.
We
Malad,
can we can have a date on this. Mr. Kaushik,
My lord.
you would be in a better position to find out the
I'll find out.
history
Well.
of this section 3 and 4.
Hmm.
Because one of the matters which was allowed,
My lord.
it was deferred with in the case of Dilip Das.
Believe this.
Then one of the matters also went up to the division bench, if I'm not wrong. I do not know, remember the result, or perhaps it had said that yes, only on completion of.
Yes.
In fact,
Like in that line, my lord, there are single bench judgments. But in division bench, I'll find out.
Try and find out if something has happened
Yes,
in the
yes.
division bench.
I'll find out. Because Nirupama Baro also has discussed the same thing, my lord.
Yes. Nirupama Baro, does it speak of that the deeming provision?
Yes.
Where is it? Nirupama.
It has in fact discussed,
Yes.
my lord, the
Huh?
issuance of notification is a must.
TV.
Yes, single.
No, Nirupama Boro was also of DB. There's Nirupama Boro.
Nirupam.
Sure.
No, it was single bench, my lord. My lord Justice Devasis was
Nirupama Baro. Nirupama Baro is single.
single.
It has gone up in appeal. Perhaps. Because it was rejected.
It was rejected.
It was rejected. Perhaps it has gone up on appeal. There were several number of cases. And there is another matter. Kalpana Borua or something. There's Kalpana Borua or something. And there's writ appeal 459 of 20235. Try and find out what happened to it.
The language is very interesting in fact of section 4. It says the services of all employees of all eligible venture education institutions under section 3 shall be deemed to have been provincialization on the date of coming into force of the act. So therefore,
This was discussed by 3 judgments, and in one of the orders, if I'm not wrong, this deemed provincialization was first given effect to by my lord. This is Buzobora as well as then. In later judgments, even while issuing notice, we went through that file few days ago. This aspect again he brought into while issuing notice saying that now that the act was not there, in view of Purnavati Brahma, can this be done? Was the notice issuing order.
But then, as I've not seen, Purnavati
This-
Brahma again
And
did not.
Justice Bhuya's orders are there and
Yes, Deepak Kumar Das was Justice Bhuya's.
this order which discusses. Now, if Justice Bhujabra's order did not take into account Deepak, then again things will change.
And
Then again, this
subsequently,
division bench on the face of Punavati Brahma not taking into consideration that, then we have to say something or we have to refer it back to one of the benches, specifically for the higher bench. What would be done now? This
And
does not take into account, but it is also there.
Look into the other judgments also.
And now Mohali Sheikh, if I'm not wrong, has gone up to the Supreme Court. Someone that they placed an order before me saying that the Supreme Court has upheld a part of it
Oh, I'm not
for the
aware.
music teachers.
yes,
Somewhere it has been upheld. Yes, yes. It was placed before me. So part of Mohar Ali now done, and this is of course my own knowledge. A review is there.
A review is also pending.
review is also pending.
So that Supreme Court judgment says the judgment not being taken up for further assailing. Review is a part of it. That was not placed before the Honorable Supreme Court. That review part was not before. There was a specific sentence that since the state has now accepted it without assailing any part of it. Therefore, now the state cannot argue. Now, if that is the position, if a review is pending, that sentence would require a review. I don't know. I don't want to know now. At this stage, I don't want to know. Now here, this order 459 of 2023, writ appeal 459 of 2023. The learned single judge opined that the petitioners were recommended merely by the district level committee. Para 45 held that the notification is mandatory and not merely an administrative order. Learned single judge took a contrary view. Hence this appeal. What has happened there? This was specifically on that point.
I'll find out this one. I'll find
This was
out.
specifically on the.
Nirupa.
No. Writ appeal 459 of
459.
2023. We will leave it to you to find out.
I'll find out.
We will not go into it.
I'll find out.
So when can we have some more material before us? Mr. Dotto, when? Heard Mr. M. Dotto, Learned Counsel appearing for the petitioner, also heard Mr. B. Kaushik, Learned Counsel appearing for the state respondents, full stop. Although this court was inclined to dispose of the repetition in view of the judgment of this or the judgment of a division bench of this court as rendered in Punavati Brahma versus State of Assam, writ appeal number 283 of 2019, Mr. Dotto has submitted that the judgment rendered by the division bench of this court in Mohar Ali Sheikh, writ petition number so and so,
Repetition number 2729.
would have some effect on determination of the rights of the parties in this particular, right of the petitioner in this particular case. Mr. B. Kaushik has sought for an accommodation to find out the relevant judgments in place before this court on the next date fixed. Mr. Dotto is also requested to have his to collect materials. So list again on
Can you do 13th?
13th of February 2026.
Let's slide on 13th the Friday.
Pardon?
Let's slide on 13th the Friday.
Friday the 13th.
Number 7, Lordship.
Ah,
I am for item number 7.
ah.
I have received affidavit in opposition. Lord. Kindly allow 2 weeks time for file affidavit.
Ms. So-and-so Learned Counsel appearing
Yes,
for the petitioner has submitted that
Similar issue, Malab.
she has received an affidavit in opposition and would like to file an affidavit in reply. List again on 13th of February 2026, by which time the petitioner shall be at liberty to file the reply.
My lord, I've got a humble submission
Ah,
in the matter of supply 26, 27, 28.
ah,
My lord, I'm an outstation lawyer.
yeah, I understand.
And day before yesterday, the matter was heard partially by my lord.
Mm.
But Learned AG was absent before lunch, and after lunch, he did not have any time. So today the date was fixed. So if my lord is kind enough to hear it today, if possible, I'll be grateful. Or otherwise, my lord can hear it Friday or Saturday. Then I'll stay back, my lord, as per my lord's convenience.
It is like this, sir. Our pleasure to hear is always there. Our attempt to hear is always there. Let's try to find out.
I'll take 20 minutes time, my lord, because the problem is that IA has been, without hearing, the IA stay has been vacated on 6th of January, my lord.
Hmm?
There is a stay against the charge sheet. If my lord remember, 24th, 11/2024, my
I
lord.
remember it was the stay. According to you, the stay was vacated because
Without
the
hearing the IA
hearing
filed by
council
the
that did
respondent, my
not,
lord.
you were not there, and
My
proper
writ
facts
petition
were.
will be infectious, my lord, in that scenario.
I will ensure it is not made infructuous either by hearing it or let us try it too once. Your item is
26, 27, 28, my lord. Supplementary.
there is a bail application which we need to hear today. 19 and 20. What no? We'll try it too, sir.
Deeply obliged, my lord. Deliberate.
You would be also here.
My lord.
We'll see what, because
Deeply obliged, my lord.
his is not for a final disposal. Even an interim, if he can convince us, would perhaps help him.
Mine
So
is
you
bad
get to
matter,
go,
but
since a bail application, we'll try to finish
lord.
it off today. Mr. Chaudhary, anything?
I'm for item number 5.
Yes.
In the event, my lord, the matter does not reach, I'll request for a fixed date because my briefing counsel comes from outside. my lord.
Fixed date would be fixed date will be all in every matter. Any inconvenience for a particular date, you may inform the court master. Will not have it on that day. We'll have it on
Always.
a date convenient to you. Item 25. Note because today we have to get up at 3:15 also
3:15.
because of the reference. We'll have a little less time. We'll try, sir.
Fine. Always.
Thank you. You would be appearing for the Union of India, madam? You are appearing for Union of India?
But in fact, my lord, in these three matter, my lord, we are led by Mr. Arkadev Chaudhary. He is at present lags at court number 3, my lord. There's a
There
continuous,
is a difficulty. On the last occasion, the interim order was not extended.
my lord.
So he fears apprehension.
My lord,
He is
my
under apprehension.
suggestion would be, my lord, my lord, can it be on 19, my lord?
And can we have your word for it that you are not?
My lord,
even
that
with
is
the
that is why
vacation
we
of-
discussed just now with Mr.
Even with the
Chaudhary
vacation
also.
of the order, since the litigation is pending,
My lord,
if we have an assurance from you that nothing happens before 19th.
my lord,
I think we will
because, my lord, prior to that it was happening. My lord, till that they had not even filed any application, my lord,
For what?
for more extending.
See, the prayer for vacation of the interim order
My lord,
has not been disposed of.
but that is the
Please,
view
please,
expressed by, my lord,
Listen to us also.
my lord.
That has not been attended
My
to
lord.
is his cry. This non-extension,
My lord,
what was perhaps he was not appearing, he could not appear in the court and someone else had appeared
Well-
and something had happened on that day. That was a practical issue.
my lord,
Non-appearance, we don't intend to continue the interim
Well-
order. We do not have any second opinion on that.
my lord.
It could well be done. Maybe rightly so. What we say is that if it is allowed to proceed,
My lord,
if even during the pendency of the proceeding, you are allowed to proceed, it would, and the litigation comes to a fruitful end.
even one
If
aspect
it
of the
comes to,
matter
if
is
it
that,
comes to a fruitful end,
my
then
lord,
all this will go in vain.
my lord, there are three matters at
Ah.
present for your lordship, my lord.
Ah.
In the first case, so far my knowledge goes, only initial interim order is.
Yes, and the
But
others there are
in
none.
two others,
We
but,
saw that.
but even though department has not taken any drastic steps, Malot.
We don't
So
want,
my
we would
suggestion,
not like
my lord, we discussed with Mr. Chaudhary, can it be on 19th for final disposal, Malot?
we'll have that. There is no difficulty on that. On
Malad.
19th final disposal, we don't have a difficulty on that.
Malot,
On the apprehensions expressed,
Malot.
would you have an instruction?
Well, so far my knowledge goes, Malot, in view of Malot, even in two others matter, Malot,
Because these
stay
matters-
order is operative.
Because
Nothing was done by the department in view of the fact that in first case, there is
your
a,
very insistence
Malad,
of not extending it
Malot.
is an indication that the
Malot,
department wants
till
the
that,
doors open.
so far my knowledge goes, till that nothing has been done by the department because the cases are before Lordship, Malot. The department, Malot, with regards, it knows the
Malad,
issue
I
is
think-
before your Lordships. So final disposal, that is why I am saying, today we are handicapped
Have
because
a discussion with Mr. RKD Chaudhary. We'll take it up after some time.
Malot.
My lord, I beg to contradict his statement
Ah,
that in item number, read petition number 5792/25, there is a very exhaustive order passed by Honorable Justice K.S. Surana on 4th of April 25.
sir, kindly appreciate.
Yes, my lord. I bow down.
You have missed the bus on a particular date here.
6th of January.
We are trying to put on a speed breaker before the bus so that you may be able to climb on it. Do not ask us to stop the bus. Clear? We are trying to have something.
19th February, my lord.
19th February is the date fixed. We'll have it on 19th February for.
My lord will be there.
Does it matter? The court would be there.
No, my lord would.
The court would be there. Not a very.
Or my lord, hear me partially. Let it be part heard. I'll take 20 minutes time. Let them argue on any other day as per choice. I'll come.
As per the deputy SGM, Malot, he continue his argument. That is why I am before
You
Lordships.
understand?
Malot,
What he is suggesting is, he makes his submissions, take your notes, 19th, your reply and disposed.
I
Can that be
just
done?
apprised the view, Malot, we are
Because the
discussing.
deputy SGI has to listen to his deputy has to listen to you.
My lord,
He is a person under request.
I humbly submit, my lord. I can make a submission for 15 minutes with lot of citation and my submission may be recorded. Let them argue. I'll just appear on the date. That's all, my lord.
It can be continued.
Since my lord has
19 also, Malot. His only 15-minute submission.
We
That
can
will
do
be
it on the
continued
19th
at
also.
19.
19th আপনার এখন আছে নাকি? We can take it up.
My lord will be
19th
there.
we take it up. And Mr. Hutoটা আছে নাকি? Hutoটা আছে তো? Nineteenth.
Highly applied.
My lord, in the meantime, I have got a citation of this honorable court and Supreme Court. For my lord's perusal, can I hand it over in the meantime?
Please.
This is in seriatim.
We are not doing we are not taking up in merits. He wants to give us a judgment. Let's.
In seriatim, I have given the headings also,
Mm.
what is relevant.
Mm.
All the paras has been highlighted, my lord, duly flagged, my lord.
It's about a disciplinary proceeding, right?
No, my lord, there are 4 aspects in the subject matter. One is, my lord, non-compliance of Army Rule 180 when the charge sheet was framed with the recommendation of the Court of Inquiry. So this honorable court decided the issue in the matter of Naresh Kumar Upadhyay in the year 2024. My lord, the same issue has been para 16, my lord. Then, my lord, same issue has
Just a
been.
minute, just a minute.
same issue has been dealt with by the Honorable Supreme Court. My lord, second vitiation of memorandum of charges, inordinate delay, all the aspects that have been covered by the citation.
And
my
in
lord.
fact, my lord, my
On
reply would be,
19th,
my lord,
on 19th.
on my
If
reply
you
would be,
can, if you can point out the particular things that this court has to see, not going into the long and
Only four issue, my lord,
elaboration.
four issue only.
We'll take up those points.
Legal, four legal principles.
in my
that's all, my lord.
affidavit in opposition, in the first case, division bench of Delhi High Court clarify, my lord. The judgment is, my lord, annexed to the affidavit in opposition.
We'll take it up on 19th.
My lord.
We'll take it up on 19th. Heard Mr. So-and-so letter counsel appealing for the petitioner. Also heard Mr. U.K. Goswami, Learned CC, who has submitted that the deputy SGI who used to lead the matter is on his legs before another court. Full stop. The learned for the petitioner has expressed urgency since the interim orders were not continued by an earlier order of this court. Full stop. Keeping in view the urgency expressed, list this matter again on the 19th of February 2026. The learned counsel for the petitioner has submitted certain citations which he would be relying upon during the hearing. Full stop. The learned counsel. List again on 19th of.
My lord, as my learned friend has submitted, that no actions to be taken in the mean period.
The learned CGC being on the learned CGC that no proceedings have yet been that the proceedings against the petitioners in WPC number Hidukono Dibo have not been continued due to the pendency of the litigation. Therefore, there may be no, therefore, petitioner in WPC number so-and-so need not apprehend at this stage that coercive action would be initiated during the pendency of the litigation.
Deeply obliged, my lord.
Yes, sir. Bail to asile. Sir, give us 2-3 minutes. We'll just finish off with the admission matters. Otherwise, we'll be kept hanging. 2-3 minutes. We'll finish it up quickly. Yes. Pleadings are complete. Matter relates to
Area salary, release of area salary.
arrears salary. Are you available on the 7th, Saturday? We'll have some time.
7.
Day after tomorrow, maybe day after tomorrow. Huh?
Lordship.
Yes? Someone from the department would be here. Consent of the parties. 7th. Yes. 7th of February. I would.
May I please, your lordship?
Mr. Midhi was required to file an affidavit in opposition.
Affidavit.
Already filed, lordship, and they also filed.
By respondent number 567. Who appears for 567? Are you filing a affidavit in opposition? No. So we can take up the matter for disposal. What does it relate to?
Relate to my pension, compassionate family pension has been stopped by MP in order, lordship.
Stopped midway.
Stopped midway, lordship.
Why?
My case.
The brother gave a complaint.
A complaint has been filed by respondent number 10
Ah,
along with a paper that stating that I am a divorcee.
ah.
My husband died.
You divorced with your husband.
My husband divorced me.
Ah, then?
The paper that is ex parte.
Hmm.
I have not received any copy, and
Of
we
the-
are living together till that.
Of the divorcee of the divorce of
Divorce order that lordship, page 42.
page 42.
Page 42.
You got a divorce and you did not know.
No, lordship, order itself reflects that ex parte lordships.
Have you challenged that order?
No, against whom, lordship? We are living together till death.
The
Okay.
husband is where?
Husband died. And that body handed over to me, then there are legal heirship certificates have been issued.
Huh?
And pension has been, a pension order has been issued. I was receiving the compulsory family pension.
If the order of divorce exists, what can we do?
Lordship, question is a paper only. It's a paper.
It is a paper.
I do not, yes, a paper. Lordship, question is that.
That is the fun
I
in
never
divorce.
communicated, husband also never told
That
me.
is the fun in the divorce. Once the divorce is granted, within the next 10 minutes, you can go and get remarried and live as husband and wife together again.
Yes, that is the law, Lordship.
And
Here
even
is the-
without getting remarried, you can live as
here
husband
is a
and wife
case,
again.
Lordship.
Huh?
Never communicated, never told me. Nobody knows. Even the husband
How can we
family,
ask him now?
even the husband family do not know.
Can we go and ask him now?
To whom, Lordship?
So that is what
We are living together. All every documents are there, and my
we will
husband-
give you some time. Kindly find out if you need to. Find out from the records of this matrimonial case as to whether the notices were actually served upon you. Did you fail
Lordship,
to
yes,
appear?
notice served upon respondents, but she remained absent.
Ah,
But I never
Fine.
received.
how do I know? I'll call for the matrimonial record, sir. You want me to do that? From the court, and then I'll decide whether it was correctly given.
Somebody might have put my signature, maybe wrong, but I have never received. Never received, Lordship, even never communicated, living together also.
Eager as we are to listen to the counsels and eager as we are to bring a quietus to the disputes, there are some things which are beyond us, which are beyond the law, which we can
Yes,
rely upon.
I know,
Now-
Lordship, but
Listen to us. There is an order of the family court.
Lordship,
True.
yes,
That order may be a correct order or a wrong order.
Lordship,
Writ court is a court of records.
Lordship,
We cannot go beyond records. True.
Lordship,
Now that record has not been assailed in any manner by you. True.
Lordship,
We cannot do it in the writ petition. True.
Lordship,
Till now we are correct.
Lordship,
When that order stays, when that order exists, all practical situations on the ground cannot be touched by us. There may be a bias in a selection process. The records show that everything was done transparently. Only the marks given in the interview were adjusted to the extent of giving benefit to some few people. Let us say, unless we find something in the records which will change our minds, we cannot interfere. Is it not? Where you have approached the writ court. The writ court would sit down to say there is a divorce. Unless till the time the divorce exists, sorry, sir. You want a sorry, sir, from us? We can give it to you right now.
Lordship. Here is the case. I was getting that by impugn communication, my friends has been told.
Because
On
they
the
were not
act-
aware of the
Lordship,
divorce proceedings.
This proceeding was secretly done. Even
Can I
husband not
decide it?
Lordship, yes, Lordship is correct. But question is, again, whom Lordship I have to challenge? There is the problem.
You would put up a review, an appeal, and whatever you want to
There's a appeal provision, but against whom, Lordship? There is the
against nobody.
Some-
You would put it against the dead person, their legal heirs, his
Legal-
brothers. I don't know.
No, no,
That is for
divorce
the
petition
advocate
against
to
whom,
find
Lordship?
out.
And may not be entailed against whom? Husband and wife. This is a divorce.
If an order has been passed on a wrong presumption that you received a notice, order has to go.
No. Order itself reflects, I have not.
You have received notice.
Order says, but no, never.
How can we go beyond the court's recording of its records?
Some time may be given in the, or in the meantime, Lordship, on that.
Was the
maybe-
exact proposition we had, we'll give you some time.
Lordships, sometime.
That
I
was my
apply.
first sentence. And today when we are supposed to get up at 3:15,
Lordships,
every 5 minutes is counting.
some time may be given,
Find
I
out
will apply.
if you have to get some relief on that divorce paper. Is only thereafter we can stand up to say that yes, if that is a dispute there, then the family pension has to go somewhere. It has to go somewhere. We'll decide where.
No, family pension.
Compassionate family pension.
Compassionate family pension.
Every person that you are
That's why.
supposed to take care of can raise a grievance that he is not taking care of me. They are before this court because you are not taking care of anybody. Otherwise, they would not be here. See, then the apportionment would come 5.3 5.14 or 5.11 compulsory family pension scheme? It is compulsory family pension scheme. 5.11 or 5.12.
5 point.
Every person who is entitled to get a pension can raise a grievance and they will have to proportion it. Go for a proportion, go for a mediation.
But proportion, all are measured.
Could be if they are entitled. If they are not entitled, then you have to get the
They are
decree set aside.
serving,
Then you have to get the decree set aside.
all are serving, 3 brothers.
How much time would you find out? You have to
Two
give us a
two-
scope to adjudicate.
2 weeks time.
2 weeks time. Learned Counsel for the petitioner has sought 2 weeks time to have instructions as to the process that may be adopted to assail the decree of divorce, which is a matter of record before this court, and in the presence of which the adjudication may not be fruitful. Mr. So-and-so appears for the respondent number
Respondent number 9.
9.
NH Borgia for respondent number 10, Lordship.
Government officials affidavit is also required, Lordship.
If the divorce is, if you can get the divorce set aside,
Their inquiry is going on.
if the divorce is set aside, you are fully entitled.
I suppose, certainly.
None of them are. They are not claiming the compulsion of family pension. They cannot. If they are majors and they are brothers, they cannot.
Lordship.
Is it?
Lordship.
Why do we need the government's affidavit now? If it comes, good enough. If it does not come, there is still scope for relief.
Lordship. After 2
List again on. Have it in March.
My Lord, can
Have
it
it
be
in
after
March?
21st March, Lordship? Can it be after 21st March, Lordship?
20 after.
After
Oh,
21st March.
21st March. 23rd, 24th. 23rd, 24th.
24.
Utilize this time. Give us something on which we can adjudicate.
How only passing time, nothing getting, Lordship.
You think this is only passing time?
Lordship.
You strike out the order and take it up for adjudication.
On 30, 20.
Huh?
Or 21.
If you're feeling sad about it, we can help you out.
Because utilizing time, Lordship.
In view of the decree of divorce, existing as on today, take a step outside, think really can we adjudicate?
Lordship.
If we cannot,
I also apply upon whom to challenge this
You have to.
question.
you have to. Otherwise, the lady goes home without anything.
Lordship.
23rd of March.
23rd of March.
May I please, Your Lordship? And this matter relating to unmarried daughter family pension. Lordship, kindly peruse the order.
Yes. Whether prior to the date of the application, you'd be entitled for the family pension or not.
Yes.
From the date of the death.
From the date of application or from the date of notification, whichever is later. In my case, Lordship, it will come from the date of application. Date of application was, Lordship, on 8/10/2019. But they have, Lordship, released the family pension during the pendency of this case.
What was the notification?
Notification, Lordship, I have an that is case, Lordship, 16. Page 16. Relevant, Lordship, page 17. Note.
Which is the relevant clause?
Page 17, note 3.
Note 3. This came into force on 9th of August 2018.
18.
You filed your claim on?
On, Lordship, 8/10/2019.
8/10/2019. Then what is the dispute?
My Lord. Now they
What are
have
they denying?
released the pension from 27/6/2025.
27/6/25. Why?
27/6/2025.
Why?
And from that date, I am getting.
Reason? Yes, madam. What is the reason?
Sorry, Lordship, I am on behalf of AG actually.
Who is
Pension-
supposed to reply?
Director of Pension Department,
Then
Lordship.
you have to step one side so that she can step
Yes,
here.
Lordship.
If you occupy the seat, where will she stand? Yes, madam.
As per Lordship, instruction dated 10/12/25, The PPO is already issued, Lordship.
For which date? From which date?
It is not mentioned, Lordship.
All right, have the concerned person here. If he has not gone through the orders of the court, what actually we need to know? The person who had given you the instruction comes here. Day after tomorrow, Saturday.
I will obtain instruction,
Half day,
Lordship.
enough time given. Bring it before 3:15. The date from which she has been given the pension,
Yes.
and if not given from the date of application, the reasons therefore. And if this court finds that she is entitled from the date of the application, the interest on the arrear pension to be paid by which officer, name, designation, account number, salary number, salary slip number. No, employee code number. Before 3:15. Kindly share the PPO. He would tell whether it's the old PPO or the new PPO. Yes.
My lord, in this case, your lordship kindly pay the last order.
Betting.
No evidence.
Who is not signing the affidavit?
PN Sharma has sent for the.
Has the affidavit returned
My lord,
after vetting?
my lord, I have telephonic instruction with the department that there is some modification is required. So within next week, they will send the message.
The last day they submitted that affidavit is ready, just
No, no,
they have
my-
to file.
No, the vetting part has to be done. sir. The vetting part has to be, this is elementary.
Yes,
Element.
Elementary.
yes, madam.
If the vetting part is required and they require notification,
Modifications.
otherwise,
Next week, lordship.
just pressurizing them is going to help always.
Yes.
Some cases it helps. The Learned Council appearing for the respondent department has submitted that although the affidavit had been prepared and vetted, some notifications are being collected. We'll stop, list this matter again and give us a date.
Weeks, my lord. Mr. PN Sharma is unaware.
Notifications of the department itself 2 weeks.
No, my lord, PN Sharma.
PN Sharma is not keeping well.
He is here.
Huh? You don't let him do the case. You want to stand. So you'd like Mr. PN Sharma to stand. 19th?
Fine.
19th of February.
Obliged.
Obliged.
By which time the department shall ensure that the affidavit is brought on record. It is given. Affidavit is filed, madam.
But no affidavit has been filed by the PNRD department.
What is the matter about? Whose affidavit is required?
PNRD to reply, Lordship.
Who is PNRD? PNRD scroll that it also. PNRD at a school. PNRD is full that look. I'll get us. But our council appearing for the respondents have requested for 2 weeks' time to file their affidavit in opposition, and Sharma Learned Council appears for the petitioner. List the matter on 22/2026. 20, you wanted 2 weeks.
Yes.
We have given you more than that. Is February. Then you should have asked for 3 weeks. 3 weeks. Make it 3 weeks. And 26th of February. But next time we are not giving date. Next time we are taking it up. Non-papers.
Family pension related.
Huh?
Relating to family pension.
How did the OBB come in between?
My lord, initially,
We'll decide on the next day.
not OBBS, stipendary teacher.
There was some order. You had it corrected. You got it corrected. CGC.
Yes. Yes, 47, your lordship, kindly have a look. His candidature was rejected at
Left in
review
membrane central perforation. Where is that medical report?
page 47. Medical report, your lordship.
Yes, 54, your lordship, kindly have a look, the last page. It was done by the petitioner, your lordship, at GMCH, Guwahati.
Page 49.
Yes. Yes, 47 is the rejection slip, your lordship. It was done. Yes, 47.
Where is that medical part? Where is it?
Medical, it starts 49 onwards.
In the advertisement or in their booklet, they must have that these are the grounds where we will not accept. Grounds for medical rejection is a clause in the advertisement itself, sir. Where is it?
That ground is within the guideline, your lordship.
Where is the guideline?
Guideline, I have not annexed that one, your lordship.
Learned Counsel for the petitioner seeks an accommodation to annex to bring on record the guidelines relating to the medical examination required to be conducted for the selection process. List again on
Any date, your lordship.
any date.
Next
Today
week.
is
Today is 5.
5. Any date? 6, 7.
No, no. Next
Next date.
week. yeah.
Next week. 9th.
Ninth.
Monday.
11.
11th of February 2026, allowing him to bring on record the requisite guidelines.
I think in the last occasion, instruction was called for, your lordship.
The requirement of the CGSE producing instruction will be continued till the next date of hearing. Then interim order we need to continue. He wants to come with instruction, he'll come.
Always.
1-5. Yes.
Lordship, in this case, a proposal was earlier sent, but it was returned back by the commissioner for some defects.
Who is the person who deals with this particular proposals?
Proposal has to go from the concern, it will be from the CEO.
CEO of what?
Chief Executive
Chief Executive Officer, Jorhat Jilla Parishad.
Is he represented? Have you made him a party?
Not
Who appears for him?
he also prepares.
You appear for him.
Lordship.
You appear for him. Ask the CEO to come. He does not know what kind of a proposal is required to be sent.
Lordship,
He has been sending proposals throughout his office career.
no, probably it might
Why
be
did
the
these mistakes come up?
present CEO might be the new incumbent also, Lordship.
So someone put it up to him.
Lordship,
Some officer sitting below him puts it up to him. He doesn't make the paper. He signs it, forwards it. Who made it?
it will be the,
Who does not know how to make it? Find out.
uh,
The Learned Counsel for the, see, next time we are going to have the person who's making mistakes be appear before this court.
Lordship, then I say some extended time may be given, 2, 3
You
weeks.
will learn.
No, if they may take the necessary steps from their part.
They can't sit there doing the same table job for years together, then make a mistake. What is the difference between an error and a mistake?
Mistake is
When you
without,
know it,
without knowing.
what is an error?
Knowingly.
No mistakes. Errors are forgiven. Mistakes may reach the level of a misconduct. Isn't it?
No.
This kind of harassment is not proper. Once you agree that he is entitled to a piece of document or some money, allow it. Hanging here and there, burdening us.
Already issue.
Is this matter again on 20th of February 2026, by which date the Learned Counsel for the respondent, PNRE department, shall inform this court the stage of correction of the proposal which was sent and returned back with objections, full stop. He shall also be prepared with appropriate instructions as to the concerned officers, as to what steps the CEO has taken with regard to the mistakes which have appeared in the proposal sent. Why does he send wrong proposals?
Can it be on 11th of March? Some little more time there.
11th of March.
Yes.
Yes, sir.
My lord, in this file matter, there are certain inherent defects. My lord, I have.
Are we prepared, sir?
No, your lordship, my senior, she is unwell today. and so she couldn't appear before this honorable court. However, she instructed me that one additional affidavit has been filed by the petitioner, which was received just day before yesterday. So we have to take instruction from the CVI. So need at
Seventh?
least, yes,
On the 7th, day after tomorrow?
no, at least 1 week.
No, no,
maybe.
my lord,
A man is behind bars, sir.
Do we have to take
Take
instruction?
your seat. We'll see, we'll ignore the additional affidavit. That will
no,
be-
my lord, my respectful submission is, so far the additional affidavit is concerned, it's only to bring on records whatever the statement that I have made in my bail petition.
We'll ignore it. We'll ignore it to his convenience. You argue on the other part of it.
So
The
7
best you can say is these are the statements which he has not made. That is the best you can say.
No,
Whatever you don't admit, we'll ignore it. But in bail cases, not the way. This could have been done in the morning when he was here.
Actually, she was supposed to come, but unfortunately,
We'll hear him, we'll see what, if it requires a objection of the level that you are seeking, we'll accommodate. Yes, sir.
Well, I can start.
Please. Bail petition, we are not putting up.
Your Lordship, may I call my senior to?
Yes.
I guess.
May I
He
please,
need
my
not
lord?
be here as of now.
My
He
lord,
need not be here. Don't impress upon her that you should be here because 3:15 is the
No,
time.
she can't.
He will not. Let us hear him. Let us see. Maybe we can put up the appropriate questions to you which can be answered immediately. Not today.
Not
Not
aware of the
today.
fact.
You can ask her to come back and answer them in a short while.
Okay.
Day after tomorrow.
my lord, so for this particular
Hmm.
incident in the FIR is concerned, it took on 3rd August 2023
Hmm.
during the ethnic strife that was in Manipur. 3rd August 2023.
Hmm.
And so far I'm concerned, I was arrested on 7/6/2025. Where
2 years thereafter. Huh.
2 years thereafter. But whatever so far the arrest memo is concerned, they have stated I was arrested on 8/6/2025 from Imphal Airport. Therefore, the additional document which I have brought on record, the particular statement is there in my bail petition that I was arrested on 7/6. Now, the additional document only shows that that from the website of the Manipur Police, that it has been published in the website of Manipur Police that I was arrested on 7/6. Thereafter, there was certain violence outbreak was there in Manipur in the evening of 7/6. Soon thereafter, from 11:45 p.m. on 7/6/2025, the total internet was shut down for 5 days. Suspension of internet. There is also a statement is there. That's the record which I have brought, the notification. My lord,
Let us come to the grounds on which you would be.
now,
pressing for-
therefore, here my whole plea is that thereafter I was arrested. After I was arrested, I was straightaway taken to Guwahati without producing me before any magistrate, any nearby magistrate out there in Imphal, which is a total violation of Article 22.
Okay. Arrested on 7/6/2025.
My lord. But
Taken
in
to
the arrest
Guwahati.
memo, it is stated 8/6/2025 from Imphal Airport.
Into Guwahati. When did you reach Guwahati?
I reached Guwahati on the same day.
7.
On the same day, I was produced before this chief.
8 or 7?
8.
Taken to Guwahati on 8th.
8. But in the arrest memo, I was shown that I was arrested at 8/6/9:40 a.m. from Imphal Airport.
So literally you were taken into custody on 7th. You were arrested on 8th and produced.
Yes.
So they have tried to cover up that time is one of your argument.
No, because they have said that in the particular affidavit which they have filed, they said I was trying to flee away from Imphal through flight. There I was apprehended in the airport. There are 2 versions has come up. One version of Manipur Police that I was arrested on 7/6. Thereafter, there was total shutdown of internet, the violence, outbreak of the violence. But the CBI says that I was arrested from the airport when I was trying to flee away from the state.
Okay.
Now, it's not covering up. Straight away, I was taken, which is on record. I was produced here at 4:30 p.m. before the Judicial Magistrate Guwahati without producing me to a nearby magistrate in total violation of Article 22 of the Constitution, meaning thereby no transit remand was obtained from Manipur to bring me out from the state of Manipur to Assam. And that has been dealt, my lord, is well aware in 2024 Priya Injuria case that has been dealt while granting antecedent bail. The transit remand is an obligatory thing, and Article 22, no violation can be done for that. So that is the inherent defect. Thereafter, my lord, they said that this particular 47 and 48 was complied with. That is what they have said. By transmitting my arrest memo through WhatsApp, when there was total shutdown and when it was within their knowledge that there was total shutdown of internet, they said it was transmitted through WhatsApp. Which media? When there was a total shutdown from 7/6/2025 from 11:45 p.m.
You are based in Manipur. Your family, your relatives, everybody in Manipur.
Yes.
So now they say, even if they say that they have sent it from Guwahati to Manipur, let us assume.
I will not get.
Even then it will not get it. Where is that WhatsApp part?
My lord, this particular in their objection, my lord, page number 254. The objection filed by
Just a
CBI.
minute. Where is your memorandum of memo of arrest first?
A memo of arrest.
First your memo of arrest, sir. Because there are so many papers. It will take us time to go through. Take your seat, sir.
My lord,
Just slightly, what is your instruction now?
She is totally unwell. Her throat, she is facing some throat problem. So she just asked me to pray before this honorable court to accommodate some time.
Let us see what are the grounds. Once we know the grounds, we will see whether they are there on documents or not. Is this the one?
my lord,
Page 83.
Page 83.
83 is the one.
83 is a memorandum of arrest. Now it says in page 85, serial number 18, page 85, inform his club secretary friend Chingthang number on his phone number so and so as the mobile number of his wife was switched off. At that time, so and so Chingthang was at his house. So information was also given to his elder sister. Now page 86, serial number 22. Due to law and order situation in Manipur, accused so-and-so could not be brought to his home. Neither CBI team could visit his home, so signatures of family members could not be obtained.
Okay.
Now,
Just a minute. You note down the questions your senior needs to answer. The first question that is coming up is, there was an internet shutdown from 7/6. That is an
from
admitted.
11:45 p.m.
There were from
11:45 p.m.
PM.
7/6
7/6. Because
2025
there was a total shutdown.
for 5 days. Suspension for 5 days.
The memo of arrest, which is signed on 8/6. The arrest is supposed to be on 8/6, according to you. 7/6 internet shutdown comes in. So therefore, even if we assume that the arrest is on 8/6, the family had to be told immediately thereafter, or the relatives. The statement here is inform the club secretary and his elder sister. Either it had to be over a telephone call or it had to be through a WhatsApp. He says there's a statement that it was done through WhatsApp at the time of an internet shutdown. Number one. Number two, even if we assume that WhatsApp is wrong and they made a call, the law requires that it is to be given in writing to them. The reason given at page 86 is due to total chaos, we could not take him to his home and we could not obtain the signatures of the family members. Done? Now, if that be so, that means nothing written was even sent to them. Not to speak of their signatures on the same. It could not have been sent to them. You could not go there. No WhatsApp. What in writing was placed before the family at the time of his production?
I understand, sir.
If his family did not know the grounds of arrest, 47, 48, we are not going on numbers, we are going on whether they came to know about it. At the earliest instance, 5 days gone, by that time remand complete. He was remanded. The remand part is over now. Before remand, he had nothing on hand. It would be onerous on the part of the CBI to have taken all the pain to find out someone, get a signature, everything. Unfortunately, law demands that. That is the problem.
I will put this question to.
We'll need the answers. Yes, now the grounds of arrest at page 87.
My lord. No, my lord.
Where is the original copy, sir? Of the ground of arrest?
Memorandum arrest next page.
No, I need the original copy, not the type copy. There is a mistake
no.
in the original, in the type
So
copy. There-
that is, my lord will find in this thing, page 99 onwards.
grounds of arrest?
Memorandum arrest, ground of arrest, my lord will find.
See, in
page-
the type copy, the looting has been shown to be on 2025, a day after he had been arrested. Please come to page 80. Do we see? Yes, page 88, clause B.
Three 2000, it should be 2023. My lord, this my lord will find in page 111, the ground of arrest.
104.
Yes, my lord. That my lord will find. Yeah, yes. That is,
Page
it says 3020 D, page 112.
Page 11?
112. Three 2023. It's a typographical mistake, inadvertent. It is
No,
2000.
there are more typographical errors. Okay, no. Okay.
Yeah.
Yes.
3/8/2023.
23. It will be 23.
No, my lord. I respectfully take my lord to the counter filed by CBI. There's a categorical statement that page 254 of the counter filed by the CBI, the relevant 254. Para 20, what they have stated, that page 254. My lord has found it. Please note. My lord, para 20, that in respect of the submission made by applicant accused in para number 6R4, in this regard, it is submitted that on 7/6/2025, a reliable information was received through source that accused applicant Kanan Singh, a member of Meitei activist so-and-so, was planning to leave Imphal through road. Flight so that he may flee away to evade his presence before the police, other agency for his examination in this case. Accordingly, a CBI team reached Imphal in the morning of 8/6/2025, and with the assistance of the source, the CBI team located Kanan Singh at Imphal Airport, and after establishing his identity, he was put under arrest in the Stein case after explaining the grounds and reasons for his arrest in this case and following all legal formalities. The information of the arrest was also conveyed to the friend of the accused applicant as well as relative as a mobile number provided by accused applicant himself in respect of his wife was found switch off. The same was also mentioned in memo prepared at the time of arrest. The accused applicant is trying to mislead this honorable by giving false information in phone of his wife was found switch off. A. It is further submitted that accused applicant himself provided the mobile number of his daughter, namely Lisa Assam, and accordingly the memorandum of arrest and grounds of arrest was shared on the mobile number. How could it be when there was total shutdown and they are aware of the fact that there was total shutdown of, because there's a government order on 7/6 and there's a statement, categorical statement in my petition also. For that, I have brought it on record. The order of 7/6, which was provided by the CBI team by the accused. It is further submitted that since the accused was required to be produced before the jurisdictional court at Guwahati, now they say that instead of producing him before the nearest magistrate, as per Article 22, now they wanted to produce in Guwahati.
The subject matter, all matters regarding to this incident had been transferred to the
Guwahati.
CBI Guwahati.
But as he was arrested, anybody can be arrested in view of section 48 of CPC.
There's a jurisdiction the jurisdictional magistrate.
My lord.
In the case of an arrest, would be the magistrate under whose jurisdiction he has been arrested. Thereafter, a remand, a transit remand would be given and it
Transit
would
remand
be
would be
produced
given.
before the, because
Yes,
suppose a crime takes place in Guwahati,
my lord.
person is arrested in Jorhat, he'll be
My lord.
produced there,
There,
transit remand,
transit remand.
produced
That-
here,
yes.
that is the
What
court.
is the law? That is the law. Article 22 says that it has to be, he has to be produced
Nearest
nearest
magistrate.
magistrate. So he was not produced at Imphal. Straight away he was brought to Guwahati. This from a state to another state. It's not even within a state. It's not even within a state. It's from one state to another state.
And in case it is for whatever reasons not possible to produce someone before the immediate near magistrate,
Lord.
then the reasons have to be recorded in writing that this is why we could not do it.
Yes. Or maybe executive magistrate.
There was a riot situation, there was this and that, therefore instead of going there, we have rushed away from
Yes,
that.
and even a requisition could have been made.
And
to
that would be reflected in the memo of arrest.
arrest. It's not reflected.
It cannot come after that.
Hmm.
Are you understanding? We'll need answers.
Now, it says to be produced before the judicial court at Guwahati within the stipulated period after the arrest, he was taken to Guwahati from Imphal. A clear statement. It is further submitted due to the law and order situation at Imphal, neither the accused could be taken to his house in Imphal, nor the CBI team could visit his residence. And hence the information was communicated through mobile phone and WhatsApp only. From where the WhatsApp will come? It is also most important to mention here that the arresting officer requested the nearby persons available at the airport for signing the memo of arrest and proceeding of the arrest, but no person came forward to do so. Now, this is so for the 47 and 48 compliance is concerned. This is as regard to the violation of Article 22. There itself, now, my lord, I have brought on record. I have made a statement, but that record was on annex. But I have annexed it in my additional.
It is not here. Your additional affidavit is not here.
But it was filed on
It
Friday.
have been filed. It is not here with us.
Anyway,
We'll have it on the next date, yes.
Anyway, if your
We'll
lordship.
take your word for it that it is there.
My lord, order 7/6. Now, my lord, I have also annexed. I'll just read out, my lord, from the official website of the Manipur police. I'll just read out. Now, because I have made a statement that I was arrested on 7/6. Now the CBI is making statement that I wanted to flee away from Imphal airport. I was apprehended at 8/6.
At the airport.
At the airport. Now, what Manipur police says? CBI and NIA have issued press release regarding certain arrests made recently, detail of which are given below. Asem Kanan was arrested by CBI in Imphal. He was a head constable in Manipur police till he was terminated from service on 3rd March 2025 for his involvement in various criminal activities, including cross-border smuggling arms. He was arrested for his criminal activities, which include several acts of grave nature and involvement in unlawful activities and criminal cases registered against him. Following his arrest, protests erupted from the evening of 7 June 2025. Manipur Police website. In the valley areas of Manipur Police and security forces, that next sentence is very important. The Manipur Police and security forces brought the situation under control. On 7th evening itself, the situation was put under control. The next phase is the notification of the government of Manipur. Now, it says on 7/6, in view of the prevailing law and order situation, I have made a statement, but I could not annex. In view of the prevailing law and order situation in the state of Manipur, especially in Imphal West, Thoubal, Kaching, Bishnupur district of Manipur, there is an apprehension that some anti-social elements might use so and so. Now, therefore, in exercise of the powers conferred under Rule 2 temporary suspension of so and so, having satisfied that the above situation is likely to cause serious disturbance to the peaceful coexistence and maintenance of public order, do hereby order suspension, curbing of internet and mobile data services, including BSAT and VPN services in the territorial jurisdiction of Imphal West, Imphal East, Thoubal, Kaching, Bishnupur of the state of Manipur for 5 days with effect from 11:45 p.m. of 7/6/2025, except for those cases whereby state government exempts and allows for whitelisting. Signed by Commissioner cum Secretary Home, Government of Manipur. Now they said it was sent through WhatsApp. In spite of the knowing the fact that the total internet shutdown was there. Now the Manipur police says that he was arrested on 7/6 and the violence erupted. It was brought under control. And CBI says that on A6 he was arrested from Imphal airport when I was trying to flee from the airport. And as the situation was not under control, I could not be taken to my residence. Which version is to be believed? And what are on record? One record of Manipur police, another of CBI. And now they say about the complaints. 47, 48 goes. Now,
when he was arrested in the airport, since the police say that it was brought under control on 7/6/2025 itself and prior to 11:45, when he was arrested on 8/6, was any person, family could not be contacted, he refused to give any numbers, we'll go by that. Was any responsible person available in the airport? Because he was there in the airport. Someone was also there. Someone else was there in the airport. Why no other person was informed or the arrest made known through? The airport would not be without a security, at least of the CISF, the level of a commandant.
Other staffs and
Someone could have been taken. And it could not be that he was trying to board a plane to Guwahati. And they were also boarding the plane at Guwahati, saw him on the steps, took him and put him inside the seat and no, nothing doing now, you let us go to Guwahati. That is not the situation apparently. He was trying to escape and he was caught. Then he was brought to Guwahati. To bring him to Guwahati, there must be tickets made. Whatever be the, however large a criminal is, you would have to have the ticket and the pass.
boarding pass and all.
It was prepared within the Manipur airport itself immediately after his arrest, having him produced here at 4:30 or 4:30 p.m. Flight is at I don't know what time. 2 o'clock from there.
The flight.
What time of arrest?
Nothing is mentioned about the
There
flight.
is no time of arrest. So arrested.
9:40.
Tickets made. Security check-in.
Security checking.
Let me tell you one more thing. This is from experience. Person would not be without arms. The arresting authorities, they'll be carrying licensed arms. In a situation like this, probably, I don't know, that needs to be deposited, verified, transferred. Then the person boards the flight. Right? We have known shooters who go for playing. Takes at least 2.5 hours at the airport. 4:30 produced. 3:30 he must have reached here. Flight must have come at 2:30. Morning arrest at 9 o'clock. Do you have the time to make the ticket, to get the gun transferred, to have the person booked and then come here? Where are the flight tickets? When was it booked? Was it booked on 7th night?
That
To have him transported here?
checked.
If it was booked on 7th, how did you know you'd arrest him on 8th? Many things will come in, sir.
Yes, yes, yes.
Have those records ready, 47, 48. Then we can see, yes, it was complied. 8 o'clock arrest, 10:30 ticket made. Decision not to produce there. 9:30 ticket made. 11 o'clock boarded the flight.
Your Lordship, I will convey all these questions. And
even
just
the video would
accommodate,
do.
kindly accommodate some
Yeah,
time so
even
that.
the video would do.
Yes, 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 definitely.
Now, in brief, my lord, that is one part.
Mm.
The second part of what they have stated in their counter is that I have been identified. I've been identified by 2 witnesses. And it is in their counter itself that
At the airport.
no, afterwards.
Afterwards, huh?
Afterwards. When they could not answer all these things, they said that I was being identified, that I was in the mob. The mob, amongst the mob who looted arms from 2nd IRV Narayan Sena on 3rd August 2023. Now, they have come up with a statement, 2 eyewitnesses.
Ah.
2 eyewitnesses. Now, the informant, so far the OE is concerned, it says that some arms personnels, about 500s. That is what they say in the
Those
OE.
eyewitnesses,
FIR.
eyewitnesses would be able to identify you or not. That would be on the merit. That
No,
will be the trial.
no. What I'm trying to say is that will be a question of a trial on merit. The informant says that in that particular, when they try to loot the arms, there are about 300 rounds of bullets were fired. So far, the information is concerned. Now, after I'm being arrested, 2 eyewitnesses come up. Now, their main contention is that I have been identified by these 2 eyewitnesses through a TIP. That is what they file in their counter. Now, the very question is, my lord, the TIP was done by the police in absence of magistrate. My lord, their own paper, their own counter.
These would be good grounds for you on in the other forum, sir.
No. Why I'm drawing your lordship's attention is the main
attempt to frame him.
Yes, the attempt to frame him.
The possibility of an attempt to frame him.
My lord, I respectfully take, my lord, to page 298 of 298. From their counter only.
Yes.
Now they say that in connection with the investigation of above named case, the presence of 2 independent witnesses, namely so-and-so, working as so-and-so. Now, this TIP memo was drawn in absence of executive magistrate. My lord will not find it's all police personnel. 2 independent, they say, from some other institute, NIT. Others are all IRB. Now, page 258, they say, it further submitted that during the course of investigation and further investigation conducted so far, in statement of witnesses have been recorded, narrating the sequence of events that took place on so-and-so. A photo TIP proceeding was conducted on 258.
Okay.
It is further submitted that during the course of examination and further investigation conducted, so far in the instant case, statements of witnesses have been recorded, narrating the sequence of events that took place on the day of incident. A photo TIP proceeding was conducted on 27/8/2025, during which eyewitnesses have identified Kanan Singh as a person who was part of the large mob involved in that so-and-so. Now, who is these 2 eyewitnesses? The incident took place on 3rd 8, 2023. Now, thereafter, an FIR was filed. Oh, sorry, charge sheet was filed within the stipulated time in 2023. One chapter over. These two eyewitnesses, which they have stated, was examined only on 27/8/2025. So, where this eyewitness was roaming around for the last 2 years, and they are police personnel of that particular, that IRB post. Now, these two eyewitnesses came up only on 27/8/2025 after
your arrest.
I'm arrested.
After your arrest.
And much before that charge sheet has been filed. On 3 occasions, they have filed charge sheet.
You
My
must have
cha-
been shown as an absconder.
No,
You are not there in the charge sheet.
I was not in the charge sheet. Even I have not been shown an absconder. See, in the first charge sheet, had I been shown as an absconder, things could have been a different. We could have read in a different aspect. But I have not been shown as absconder also. On 8/6/2025, I was arrested. Another supplementary charge sheet was filed. No whisper was made in the first charge sheet about me or what was so-called Arambai Tengol. For more than 2 years, they have not made any whisper about Arambai Tengol. Now whisper about against me. After I'm arrested, the Arambai Tengol has come in between. And these two eyewitnesses have come out on 27/8/2025. So it's nothing but it's a frame-up case. That's what I want to draw the inference of your lordship.
Okay. Now, this matter was initially we had fixed this matter as a part out on 18/12.
My lord.
Was required to be listed again on the 22nd of
Lord,
January.
Unfortunately, that was
Somehow
not
it was not,
listed.
it was not there. On 28th of January, this matter came up again.
Yes.
When we have fixed it today. What is the first instance when you can come, when madam can address the?
On Monday.
No, Monday, maybe on Tuesday. If
Tuesday কেটা আছে? You already have 19 criminal.
My lord, I'm behind. No, see, maybe on 7, because 7th I'll give it, because I've spoken with my sister. So he didn't say about his health. He didn't say about it. He only said that you have filed so and so, so and so. You start your argument. I'll do my part on 7th. That's telephony.
7th, she had agreed to. Then why not agree to 7th, sir? 7th, we'll have a little less laborious list.
That will be a first remarkable day also. We'll be sitting on Saturday.
So
Saturday. 7th.
The additional affidavit, he has assured he has brought on record only the notification of the government and the, what do you say, the statement made by the police that so-and-so was arrested and then we had to calm it down and all that. That part they have brought on record. So that would not require, that is available in the website. Have a verification done if it is available in the website.
Only particularly that part.
That is the only additional affidavit he has filed. He has not brought on anything new.
I have not brought
Only in support of what was made in the bail petition. Last occasion, if I remember correctly, when it was taken up in December, I had raised this point. How do we say that you were arrested on 7/6? Perhaps you are not appearing on
No, I
that day,
was
someone
there.
else
We
was
did
there,
it.
and they had made a statement that there is a document which shows that after my arrest, there was a halabu and therefore things had changed. We could not find that on record. That is why the additional affidavit has come up to bring that piece of document. And otherwise, the other questions that we had put, if it's short, we'll not make it too long. We'll do it on 7th.
7th.
Although had it been a repetition, we could have afforded time. Something which is personal liberty. If it has been violated, we have to pass orders. If there is no violation, he may cool his heels for some more time, there will be no difficulty. We'll do it on 7th. At the request of the Learned Council appearing for the CBI. Place this matter again on the 7th of February 2026. Obliged, obliged.
Obliged, my lord.
Mr. So-and-so has been heard at length. The matter is fixed for reply by the prosecution. CBI, by the special counsel for
Pending
CBI.
counsel.
We'll have it
I
in second.
may, my lord, another 10 minutes, I may have to argue because some other points are also.
We would rather say that if one point is good enough, why hammer the whole coffin?
Obliged, my lord.
Obliged.
Yes, sir, something quick, we have to rise in 3 minutes.
May I please your lordship? Lordship, the director of pension seeking 3 weeks time to review and correct the order, lordship.
Would you like to do it sitting down here? It
Lordship,
will take him half an hour, he can come down, he'll sit down and do it.
lordship, 2 weeks time.
Why? It's a pension.
Lordship, I know it, lordship,
a
but
pension.
he's getting prompt
10, 8, 10.
He's receiving a
What is the objection?
nothing is mentioned, lordship, but they just informed me that, verbally informed me that they will correct it by the 2 weeks.
Maybe if we press some more, it will become 1 week.
No, lordship.
Place
Not-
this matter again on the 23rd of February 2026, by which time the pension department shall ensure that the necessary PPO, because the PPOs are
Will be
issued. Is the matter relates to family pension,
Unmarried daughter pension, lordship.
unmarried daughter pension, comma. This court would put the respondents to notice. And I like to cut it. We are not being strict this time, but on 23rd. 24th, he may be sitting here and doing the work. We'll have it done by the 24th.
Lordship, I will,
If you agree that she is entitled to a
yes.
pension payment order, if you dispute it, we'll hear it and we'll
Lordship.